Yeah, I'm going to do it in 2 seconds.
I was curious myself. Ask me a question. What does that do?
I'm going to call to order. I call this meeting of the West Hollywood Rent Stabilization Commission to order. Will you please join me for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Secretary Barrino, may we have the attendance?
Commissioner O'Keefe.
Present.
Commissioner Kerpes.
Here.
Commissioner Maggio.
Present.
Commissioner Martz.
Here.
Commissioner Topchian.
Here.
Vice Chair Bergstein.
Present.
Chair Charity.
Here. Thanks very much. Moving on from item 3 to item 4, approval of tonight's agenda. Commissioners, having reviewed tonight's agenda, do you have any amendments or a motion to approve?
I have a suggestion for my fellow commissioners. We have a fairly ambitious agenda with 4 items under new business, and the most time-sensitive of those issues is B, discussion of one-year lease zone text amendment. So I thought perhaps we could move item B to the first under new business, so that might get covered tonight, and then we could move on to the other items under new business.
I'm fine with that. I'd second the change if no one else has any objections.
Objection? No, none from me.
Very good. Staff, does that require a motion to approve, or can we just move item B up?
You can move item B and then just approve the agenda as amended.
Thank you very much.
So move to approve as amended.
And I second. All those in favor, please say aye.
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 Thank you very much. Moving on from item 4 to item 5, approval of the minutes of our last meeting, March 14th. Commissioners, having reviewed the minutes of our last meeting, do you have any amendments or a motion to approve?
I do. On page 5, it says that the vote on the motion on the appeal, the D-4384, was 7-0, but it was 6-1-0 because I ended up voting against it because I would have called the paint exterior, not interior.
I'm sorry, which appeal was it?
That was D-4340, oh wait, yeah, 4348. So it's the last line before public comments. It should be 6-1-0, not
Right, the
7-0.
motion was approved by a vote of 7-0 is how it shows, and it should be a motion approved 6-1.
Correct.
Thank you for making that amendment. Commissioners, any further amendments? Do I have a motion to move as amended?
I'll make the motion to approve as amended.
Thank you.
Second.
Thanks very much. All commissioners in favor, please say aye.
Aye.
And all opposed? Thank you very much. Our minutes are approved. We're moving on from item 5 to item 6, public comment. We have 2 public comments this evening. Public commenters, please remember that you have 3 minutes to speak. When you do come forward, please speak into the microphone and state your name and city of residence. Our first public comment is Mr. Ted Green. Okay. Would you like me to hold it until 10B? Okay. Sure, that's fine. Our second public comment, Ms. Graciela Ipaguirre. I may have pronounced that incorrectly, and forgive me.
Good evening. Graciela Iparraguirre, West Hollywood resident. I'd like to talk about creating a length of tenancy fee for no-fault evictions by bringing into consideration the length of time a tenant has occupied a unit. These tenants, mostly seniors, have lived in their beloved units often for many decades. Presently, tenants who have lived in their units for a very short time get the same amount as tenants who have occupied their units for a great part of their lives. The longevity and inoccupancy should be recognized and factored in by an additional fee. There are many ways to do this and many amounts which could be considered. My proposal is Keep the rules and relocation fees as they are at present and add to them a length of tenancy fee. This fee would apply irrespective of age, income, and size of unit. It would be for tenancies of 10 years or longer. Starting at 10 years of tenancy completed with $10,000, it would increase $10,000 per 5 years of tenancy. Any length of time shorter than 5 years would receive the smaller amount. For example, 12 years of tenancy would receive the amount corresponding to 10 years. The notifying periods with the 1 year extension would be included in the calculation of length of tenancy. The way to calculate this new added fee, as shown in the chart, is very straightforward and could be easily used by city personnel, landlords, and tenants. These amounts are very reasonable and should be the minimum long-established tenants should receive. The city needs to reevaluate this reality many seniors are facing and do some kind of increase for tenants who have occupied their unit for long years and now, as elders, often in poor health, have to go through the difficult and heartbreaking task of leaving their beloved homes forever and finding a new place to live. Please establish a length of tenancy fee. Thank you. Also, Mr. Chairman, I would like to give you a copy to all of the members. So you can, I was told to ask you for permission.
Yeah, I'm fine with it if the commissioners are. I'd like to see what you have. Thank you. You need a copy, right? Will she get you a copy too? Okay, we'll get you a copy. Thank you.
Thank you.
Thank you. Moving on from general public comment from item 6 to item 7, our director's manager's report. We'll have that now from staff.
Hi, good evening. Before I start my report, I really want to acknowledge, as you may have known, we have had the info coordinator position vacant for quite a few months, and we finally hired somebody new. She's actually here with us tonight, Yasmin Spiteri. She's in the audience. She actually is coming from a nonprofit organization. She used to work for the Housing Rights Center, so she has a lot of knowledge with landlord-tenant rights. So we're very lucky to have her. In regards to the report, I'm just going to go through the meetings that are coming up and what things are going to be heard. Our April 11th meeting shows a schedule of 2 appeals, as well as the April 25th, May 9th, May 23rd, and June 13th. All of them are filled up with 2 appeals each.
Thanks very much. Commissioners, any comment or questions for staff?
Just a quick one. I want to welcome Yasmin to the city of West Hollywood. I know her for a number of years for the great work she did for the Housing Rights Center. Welcome.
I have one as well. I'd like to welcome you also, and then I will note that for the April 11th meeting, I will be out of town. Thank you.
Just that I've had the pleasure of meeting you earlier on and welcome you to the commission.
Commissioners, anything further? Very good. We'll be moving on from item 7 to item 8, commissioner comments. Commissioners, any comment tonight? I'll just say happy birthday to our housing manager, Peter Noonan. Commissioners, also, your Form 700s, if you haven't filled that out, I believe they're due on early April 2nd, the next Monday. So ensure those disclosure forms are done so you don't possibly incur a fine. And also, I echo the congratulations from my former commissioners.
I did not receive that form. Are there any extras tonight? It's in the email?
Got an email from Melissa.
Today?
Yeah, Melissa Crowder will be an email from probably early March.
I did not get that email for some reason.
I don't
Thank you.
think I did either.
I think we can do that online as we did in the past.
Yeah.
Is that not correct? Thank you.
Yeah, exactly. Well, I see no further commission. Oh,
Yeah, I just wanted to say 2 things just to clarify. I think it's Monday, April 1st, right? It's April 1st unless it's a...
I believe
What is April 1st?
Yes, yeah, I believe it's April 2nd, though, but it's early next week, I know that. I think the deadline was April 2nd.
And then the other thing was, I will be absent, I think I mentioned it to our secretary, but I will be absent May 23rd.
Okay, very good. I think that is it for commission comments. So we can move on to tonight's appeal. We're moving on from item 8 to item 9. Our appeal tonight is D-4357. The address is 1216 Crescent Heights Boulevard, Unit 16. This appeal was filed by both parties, so I'm just going to check for the parties' presence tonight. The tenant is William Horn. Mr. Horn, are you present? Thank you. And our landlord is Steve Short. Steve Short, are you present or represent? Thank you very much. So at this time, we'll have a report on this appeal from our staff counsel, Allison Regan.
Thank you. In this case, the tenant filed an application for a rent decrease and claimed that the landlord had substantially reduced the amount of natural light coming into his apartment. The hearing examiner agreed and ordered a $4 rent reduction until the conditions are restored that allow the natural light into the unit. Both the landlord and the tenant have appealed. The landlord argues that there was no substantial loss of light, and the tenant argues that he is entitled to a greater rent reduction than ordered by the hearing examiner. Staff recommends that the commission affirm the hearing examiner's decision. There is substantial evidence in the record supporting the hearing examiner's determination that this housing service was substantially reduced, as well as evidence supporting the amount of the decrease. Thank you.
Thank you. Commissioners, questions for staff?
Quick question, if I may. Ms. Regan, I know you're going to say it's irrelevant. However, I want to know what's the current rent amount, if you know, that the tenant pays?
I do not know. I can look that up. I'm sure it's in the decision. In fact, it's probably in your packet. If you look back to the actual hearing examiner's decision, she normally notes that in the decision.
Yeah, Commissioner Topshin, yeah, the only thing I saw was on page 57 of our packet.
Yeah, I wasn't sure.
Yeah, that's an item 2, what it was when in 2010.
Right. I wanted to know the current rent, but anyways, thank you.
A couple questions. One of them is, I'm wondering if we ever before have found both the presence and the absence of something to be a housing service. In this case, in the past, shade that's been over a window has been a housing service. And in this case, if we were to agree with the hearing examiner, we would be finding essentially that the absence of shade would be a housing service. And is there anything else that we've found, you know, having a tree or not having a tree that both ways could be a housing service?
Yeah, I mean, I suppose you can declare it either way, right? The absence of sunlight versus the presence of shade. So either one of those housing, so we have found a reduction of a housing service when there was an awning, for example, and the awning was removed, or whether there was natural light and the result was just the opposite. So yes.
Thank you. And I'm wondering, I think this might be the first new housing service where I've seen findings in the staff report. As far as I can tell, that wasn't information that was presented to the hearing examiner, things like the benefit of natural light and vitamin D, and I'm wondering how that works. Is that procedurally that can be just added after the hearing, or was it presented during the hearing?
It was not presented to the hearing. That was something that I did research on myself, and it was to support the legal determination. So this was more of a legal question rather than a factual question, and that went toward, is this an actual housing service that can be considered a benefit of the tenancy? So that was just to assist the commission in determining that it can be a housing service.
Okay, and then if, so I noticed vitamin D and it made me curious. Can you actually get vitamin D through a window? And I looked quickly and it looks like some glass can, but most glass can't. I'm just wondering for the landlord, is there ever, if they were to contest any of the specific findings that are the basis for finding that it's a housing service, would they do so here, or since it's not presented during the hearing, how would that work, if at all?
Yeah, I mean, if they disputed any of that, they could.
Thank you.
Just briefly, what is in our folder on the table tonight? It's a 2-page document with copies of the face pages to both of the appeals. Was that anything different than what was in our packet? I'm not sure why it's in our folder.
Oh, no, it's nothing different.
Okay, thank you.
Well, I should say it's the complete appeal, so what's not in your packet is the backside of the appeal form.
I see.
So I just wanted, for completeness, we provided you both.
Thank you.
Okay, and I'm sorry, one more. So I noticed that they said that this tree had been there for 2 years. And so in the past, other cases I've found that presence of a tree can be a housing service. If the commission were to rule for the tenant, could another tenant then, if the tree was cut down, be awarded money for the absence of a tree?
Well, again, it would depend on the conditions that were there before. So it's not a hypothetical that I can really answer.
I have one question that we may have the same answer to, a hypothetical, but it was mentioned in the, I believe the appeal, the tenant said, not only is this shade in my apartment or I'm lack of light, but as the tree grows larger, I will have less and less light. Will this open up, will the tenant have the right to come back at a later date, should that be the case and there be a lesser amount of light than what she's receiving now?
Yeah, that's a great question that I don't know the answer to. I mean, I suspect not, because I don't think the determination was based on a percentage of light. I think. So, again, I think at this point, I would encourage the commission to focus on what's in front of you.
Thank you.
Ms. Regan, just a procedural question. The commission can, if disagrees with the amount of the rent decrease, the commission may entertain a motion to change it, right?
Yeah, assuming that there is a finding that no evidence supports what the hearing examiner did.
Okay, thank you.
Commissioners, any further questions? Very good. So, gentlemen, we'll move on to our rules of engagement for your oral argument tonight. Because you each filed an appeal, you each have a total of 5 minutes to speak to us this evening, but you both can divide your time to rebut arguments of the opposition party. So when each of you begins speaking, you'll have to tell the staff if you'd like to speak for a total 5-minute block, or you'd like to divide your time perhaps in 3 minutes to allow your party to speak, and then have 2 minutes of rebuttal time. Please understand we cannot take any new evidence from you tonight. We can only examine what was in front of the hearing examiner at the time of the hearing, and please understand we are strict with the rules. We will cut you off if you do talk over your time limit. Also, please understand that we cannot respond to you if you ask us questions. We have to take your oral argument and take the hearing examiner's findings, take the evidence on the record, and use that for our deliberation when the time comes. Mr. Horn, you are first, so please be sure to speak into the microphone so we can hear you and it can be on the record. And please, as I said again, let the staff know how you'd like to divide your time.
First, I have my speech written out if any of you would like it. I've been told that you would be able to accept it. Staff here is telling me that you may not, but I have copies for all of you as well as my landlord. It's basically what I plan on reading to you. If you would like it in front of you, it would be easier for you.
We'll have you give it to staff and we have to
They wouldn't accept it.
Okay, well, then they've made then that's the staff's ruling.
Okay, that is fine.
Because please let them know your time.
Just until I finish the reading. Although the hearing was determined in my favor, I was erroneously awarded only $4 reduction. Briefly, the allowances that the city has provided my landlord need to be mentioned. On the January 17th deadline, landlord filed an incomplete appeal that didn't provide proof of service. On January 28th, city gave landlord extension to file an amended appeal by February 11th. I have the letter and that attached if you would like to see it. I think the city should have enforced its own regulations as they are written, but it didn't. Further, I asked the city at least to acknowledge these facts in the staff report, and the city refused to do that as well. The extension provided was not met either. I also have never received any notice about this hearing from my landlord. Moving on, there are many reasons why I am due more than a $4 reduction. First is the city's unjustified logic that sunlight and darkness are equivalent and should be treated the same. The hearing examiner's decision correctly states that the RSO guidelines do not provide evaluation for loss of natural light. The decision then analogizes loss of sunlight to loss of shade, But the loss of sunlight is actually far more significant than loss of shade. The many health and mental health benefits associated with sunlight are fully acknowledged in the staff report, and actually they were mentioned in the hearing when I actually mentioned clinical depression in relation to sunlight, but I did not mention vitamin D. I'll acknowledge that. There are no such benefits associated with darkness. Seasonal affective disorder is a real, legitimate, and serious result of lack of sunlight. There are also financial benefits to sunlight. For instance, I have had to buy lamps for my living room, and my electric bill has increased. Removing sunlight is also different and more serious because I could, as a tenant, could take steps to restore shade. Shade can be restored with blinds, curtains, drapes, hanging plants, adhesive stickers, and many other things. There is absolutely nothing I can do to restore sunlight to my unit. Not one thing. Also, sunlight is more serious since loss of shade can be repaired. A tree can regrow. A shade can be replaced, but sunlight is not growing back in my unit. In fact, the situation is only going to get worse, and my apartment is going to get darker since trees tend to grow. This should be acknowledged in the evaluation, and it was not. The likening of sunlight to darkness is a major failure in the evaluation, and it diminishes the severity. Another failure in the staff report is the reliance on the falsehood that the guidelines provide evaluation for shade. The staff report contradicts the hearing examiner's words when it states, in quote, "She found an analogous housing service, loss of shade, to determine valuation." The examiner never said this, only cited precedent, and the guidelines provide only evaluation for sun shades, as in a parasol, an awning, or a beach umbrella. It does not mention shade. The word shade, when defined in context and relevantly, has no plural to it. You would never say, "I'm going to lie in the shades of the trees." We're not talking shade as in an umbrella. Here, shade is being used improperly. The accurate definition has no correlation to the valuation in the guidelines that is cited. The guidelines' use of shades in the plural sense even proves this. The city is taking two giant leaps of logic. First, that sunlight is analogous to shade, as in darkness, and then shade as in darkness is equivalent to shade as in a parasol. Neither of these statements are accurate, and they both greatly minimize the reality of what's going on in my unit. A $4 reduction might be appropriate for the loss of a parasol. $4 is not right when my landlord's actions have removed so much sunlight from my unit, altering my life as it has. This is magnified by the fact I was receiving a $39 reduction for a room not being repainted. How is $4 appropriate for cutting off all my natural sunlight and all the severe health issues this causes when $39 was awarded for not painting a room? This is nonsensical. If you still choose to accept the examiner's and report's logic, 4 trees would at least be equivalent to 4 shades. That's $16 minimum. The guidelines also provide a slightly more accurate and overlooked valuation that should be taken into account. That is of gardening and landscaping, $22. There's 4 instances of that. That would be $88. Both significantly more than $4, and these should actually be taken in tandem. These valuations don't even take into account the financial, health, and forward-thinking aspects of growing trees and the light it's taking away from my apartment. So without even accounting the health effects, that's $104, a great disparity from $4.
Thank you, Mr. Horn. That is your 5 minutes. However, commissioners, do you have any questions for Mr. Horn?
I do, but no one else does. You stated just now you had to purchase 2 lights. Is that
Two
two additional lamps, right?
My unit has no overhead lighting. It's an old unit. Everything is a lamp.
Just answer.
Yeah.
So, because I think you would mention it in the hearing as
Yeah,
well. You had
that's fine.
purchased. Is it 2 lamps? Is that?
At this point, it's actually 3, but I said 2 because I'm not allowed to new information. But yeah, it's 3 now.
Well, I think you did say 3 in here. I think you said you went
Okay.
from 5 to 8.
It was 3.
That's what I was
So
checking.
yeah, it's actually an additional one now. So there's 4 additional ones now. 1 more since the hearing date.
So my question right now is so did you go from 5 to 8? Is that accurate?
There's 9 now.
So we know it's more than 2 or 3.
Yeah.
Okay. Thank you.
I just want to ask you, what's your current rent?
I couldn't tell you off the top of my head.
Mr. Horn, I'm just curious in that spirit of just trying to solve problems between landlords and tenants, what would make you happy in this situation? Is it the money, or do you want the light? I'm just curious.
I've already discussed that with my landlord, and the reality is my apartment is cave-like. It's dark as can be now. I even discussed this morning, moving them to the front of the building where they've actually removed multiple trees. My unit is so different than it used to be. There is no light at all. I would like the trees moved. $4 is absolutely not going to cause the moving of a tree.
Thanks for enlightening us. Thank you. Any further questions?
Does the gentleman have this packet with these photographs?
I don't, is the packet with the photographs available, or were those
Part
photographs?
of the record, so they have already seen them.
And were those photographs provided by you? Do you want to hold it up? Maybe
Between the two of my
Between
landlord
both
and
of you.
myself, I assume all of them were provided.
Yeah.
Is this your apartment?
May I come in closer to see?
Yeah.
Yes, that would be my kitchen window, and that would be my living room.
And this is the tree, right?
There's actually 4 trees.
Now there's 4,
There's 4 in front of my window.
and this is only showing 1 tree.
So basically, are you saying there are trees that are not in that picture?
May I see the, actually, in here, so I think that's not.
Yes, I think it's on page 32 that he's looking at,
Okay.
of the packet with the numbers on the,
There are 4 trees. As you can see right here, this is from the inside looking, yes, there are 4 trees in front of my unit.
could you tell me which, I know you submitted some of these, is one of these the before picture that you took, and if so, which page is it on?
If you'd like, I can go through each one and tell you if they're provided by my landlord or myself, and he can step up and verify this if that's something that's concerned to you.
I just want to know, this is the now, one of the now pictures, and if you can just show me which one is the before, and it should be numbered the same in your packet.
Can you
so we
reference
can-
the page numbers as you go through as well? Reference the page numbers as you go through as well?
Certainly. And the one we were just looking at is page 32 is an after picture.
Actually, the before is not even in here, which is very disappointing for me.
Page 30, 37, and page 30.
No, neither of those. I can show you on my phone right now if you would allow me. The before is acknowledged.
But I mean, I can get it, commissioners, that I see trees in the window.
There used to be no tree at
Right.
all. The before picture demonstrated that, and that's even acknowledged in the hearing examiner's decision, so I'm actually very disappointed.
Page 20 is the before picture.
Page 20.
Yes. That's how it used to look. There were no trees. Is there any other questions I can answer?
Oh, I see, yes, okay. Page 20 is the before picture, commissioners, like what the window looked like looking out of it before. Okay.
Any other questions I can answer for you?
No, I have a question for staff.
Well, yes, so Mr. Horn, you're done. We'll move on to our next speaker. And you want to save the question for staff
After that,
commission
after
comments?
that, after
I mean,
that.
for deliberation, thank you. Okay. Mr. Short, you'll have 5 uninterrupted minutes to speak to us.
First of all, I want to thank everyone for their time. I'm really sorry we're at this point. I appreciate the commission's time. We did try to avoid this by trimming these plantings multiple times over the past few months. They're now on a different trimming schedule than the rest of the property. And we did this to try to work with Bill. We like Bill, he's a character, but in this case, we really disagree with his viewpoints and that of the staff as well. I know they're getting it from both ends tonight, but I'll just try to be as honest as I can. I think my argument can be broken down into 2 areas, basically. Number 1, there was no substantial loss of a housing service. There's not a substantial loss of light, in my opinion, in our opinion. And I think it's evident by looking at the pictures submitted by all parties, staff, landlord, and tenant. When you read through the decision, like I know you all have, the examiner seems to think the argument seems to be there are plantings near the tenant's window, so the loss of light simply has to be substantial, as opposed to the sunlight is substantially diminished because of the plantings. Now, while the examiner did indeed prove there are plantings, she did not prove there was a substantial decrease of light because of them. Number two, I don't believe the city followed rent stabilization regulation 60009C, which requires that the examiner at all times perform in an impartial manner. The landlord, but not the tenant, was excluded from a post-hearing inspection that the tenant got to be present on. Further, I don't believe the staff was impartial because they did not follow the examiner's very, very specific instructions, as I'll lay out for you, in which I believe this caused harm to the landlord. So back to one, no substantial loss of service. I think this case is ultimately about pictures, the pictures you see before you, and the lack of data they provide. I think everyone's here taken multiple selfies to get the right angle, right? I think most of us have, but why is that? It's because pictures are a lot about lighting and angles and other random factors. And because of all these different variables, you really can't judge with any accuracy the amount of sunlight in the tenant's window based on just the pictures. It's too subjective. You really got to have the facts. And I think we all can agree when people look at pictures, different eyes will see them in different ways. Pictures will be interpreted multiple ways by multiple people, which underscores the fact that you really need to measure light if you want to get it right. And to sort of have any true understanding of the light coming in an apartment years ago on date A, before the plantings, and date B, after the plantings, sunlight would just have to be measured. There are many different ways to do this, and even after the fact, the tenant didn't try to measure the sunlight at all, nor did he bring any data to the hearing. You can't go on feelings. Honestly, if feelings and guesses mattered, mine would have put Trump in jail a long time ago, which is where I think he should be. But even if, and I think this is a big if, the before and after pics submitted appear to one of you to have substantially different light, it could be for any number of reasons. Different camera settings, different quality cameras, pictures taken at different times of the day, pictures taken at different angles, the quality settings of the printers that were used to print each image, the quality of the paper used when printing the pictures. The record itself on pages 33 and 34 shows that the tenant himself stated that sunlight only enters the window's picture between 9:30 and 10 a.m. That's about 2% of the day, or to be fair, we can call it 4% of the daylight hours. Even if there happens to be a slight decrease in sunlight, it's a minimal one, and only minimal just for the 30 minutes of the day when the sun hits those windows. How much time do I have? Could somebody tell me? Okay. I'd like to note Exhibit 5.1 on page 20 that you guys just looked at. It's the upper picture. This before picture, which looks to be altered because it's really, really bright in the middle of it where there's a building, or it could be light reflecting off the window. It seems like that unit gets a ton of sunlight, but like Bill stated, his unit is cave-like. It's a bottom floor unit facing a small courtyard where there's a building about 15 feet away, a two-story building about 15 feet away. So it's not going to get a lot of sun. And when you compare 5.1 on page 20 to Exhibit 7.5 on page 32, that's one of the landlord's picks, the actual light in the window is pretty much the same. Yes, you see trees, but do you see diminished light? No. And even when you look at the staff's picks, on pages 36 and 40, Exhibits 8.4 and 8.8, I think you can draw the same conclusion. Even the one where it's dark all around the window because they focused right on the window, causing the blackness to appear around this big lighted window, you can see that there's a ton of light there.
Commissioners, do you have any questions?
I have a couple of questions. How many trees there are now? 4? How
Right
many?
in front, 3, I believe, yeah.
3.
According to these pictures,
So
yeah.
that one of the pictures, or several pictures, they show first 2 trees were planted initially, right? At the beginning, and I believe the tenant also testified that. And in some of the pictures, I see there were 2 trees.
Oh, in the before pictures?
Exhibit page 28, page 29, page 30, they show what I see 2 trees. So at one point, the 3rd tree was planted. Now, my question is, when 2 trees were planted, did the tenant mention or brought up to your attention that he didn't like the trees being planted in front of his unit before you planted the third one.
Not initially, but a few months ago, he started bringing it up, so we trimmed them. And we've kept them on a really strict trimming schedule so they don't get overgrown, and I you know.
But there was nothing, no email, no call? That would
Not when
say-
they were first planted years ago, no.
And you are the owner of the property, right? You have a.
I just work for the owner.
You work for the owner?
Yes, sir.
And you reside on the premises?
No, I don't.
Is there an on-site manager?
There is an on-site manager, yes. He's a part-timer, so.
Do you know if the on-site manager was informed about the tenant being, unhappy with the trees in front of his unit? If
This
you know.
current manager has been there a little over a year, so he wasn't around when they were first planted, but about the time Bill was talking to him, Bill was also talking to me at the same time. And that was, a few months ago when all this started and we started trimming that area just for him.
Okay. Thank you, Mr. Short.
Commissioner Raggio.
The larger trees next to it are the same type of trees, isn't that correct?
Yes, I believe so,
And
sir.
they're a palm tree, aren't they? A pond fern, I think they are.
I believe it is a fern palm or
They
palm
grow
fern.
very tall and they're, have a large bottom and they fan out at the top. And these are how new are these other trees, the smaller ones?
In that area, I believe 3.
How new are they?
I believe they were planted 2 to 3 years ago.
2 or 3 years ago. Okay, thank you very much.
On page 20, the before picture, it looks like there's some foliage in the upper left that's not of the same type that's there now. Do you know what that is? Was there, I read that there were short bushes in front of it, but it almost looks like there's a tree or something, like the upper quarter of the window looks like there's leaves there.
Yeah, I believe that's a tree on the other side of the courtyard, about 12 to 15 feet away.
Okay.
But as you can see, that blocks light too.
Thank you.
Question. So you submitted photographs, is that correct?
Yes,
Some
sir.
of these, and the tenants submitted some of these photographs, did you have an opportunity at the hearing to see the inspector's photographs, or were those taken after the hearing?
They were taking after. We didn't even know about it until
So this is the
much
first
later.
time you've had an opportunity to make an argument about the city inspector's photographs, right?
That's the first time I've had to make an argument, yep.
Thank you.
Commissioners, anything further? Very well, thank you very much.
Okay, thank you.
We'll move on to deliberations on this appeal. Who would like to start? I think there was a question for staff, Commissioner Topchian.
Yeah, I think that's what I wanted to clarify, the number of trees, but the landlord, the property owner's representative answered to the questions. My other question would be regarding the examiner's request for the code enforcement officer to take pictures of the, did the inspector visit the property and take pictures?
There was an inspection report, yeah.
Inspection report. And the actual report is here in the packet?
Yes. Mhm.
I had a hard time to find it.
50 or so.
What was the page number?
It's like 50.
Because I saw the pictures, but
Page 33 and 34.
Close to 50.
well, so this is the actual report. There is, because I read this, but I thought there is a report as the when the inspectors go out for some other habitability related issues. The report, the formatting is different. I wondered if there was a report that in a different format.
You might be thinking of a code compliance officer. This is not a code compliance issue. This was an inspection made at the hearing examiner's request. So that's typically done by rent stabilization staff.
Oh, okay, so not the code compliance officer, so that's what I was probably confused with. All right, okay, thank you.
Commissioners' deliberation?
I will start, I guess. I sympathize, the tenant seems objectively to really not like the trees, but I am a bit wary of making a decision first that it's a housing service to have the absence of some shade caused by trees. Trees grow, trees are good for the environment. We found that shade is a benefit to people. In this case, the trees have been there for 2 years, and it sounds like it wasn't raised until they'd grown for 2 years. So at this point, it's already a housing service for people that like trees, presumably. So I'm a little torn on that. And then just the images, the question of whether there's substantial evidence that there's a substantial decrease in housing services. To me, the photos on page 32, it looks like the amount of space that's blocked by trees isn't substantially more than was blocked by foliage on the picture on page 20. And that's my thinking for right now.
Yeah, I'm struggling with it too, because I see the base of the tree trunk looking like it won't block sun, and as the trees grow, the problem could alleviate, or could it get worse? Does it block more sun? And I think, you know, we obviously have a changing situation where we're putting in place a permanent rent decrease, so that's, you know, we're putting in something permanent for something that's going to be changing. So, I mean, I'm struggling with it myself. I think, you know, for later, this is something we have to add to your list of things in the rent stabilization ordinance that need to be covered. But you know, I see the hearing examiner was doing her best to, you know, figure out a situation where we didn't have, you know, a lot to go on in the ordinance. But I am interested to hear what everybody has to say.
So I just want to I want to caution my fellow commissioners in terms of looking at it beyond what the service is to this tenant. And whether it's a value to another tenant or it's a loss to another tenant, because we can always go down that road. Well, if they cut down the tree, he's restored, but what happens to the neighbor? And I would caution against that. We often make decisions that are violations of code where we have fairly consistently, I believe consistently, but I'll say fairly consistently just to make sure I'm not missing anything, but we have said code violation is at no fault of the landlord. They're required to remove it because the city comes in and says you have to remove it, but it's still a removal of potentially a service that the tenant is going to, a reduction in service. So we've been consistent in making sure that the tenant is reimbursed for that or is put right at that. We've also, you know, in buildings where the cable wiring just got old, they stopped providing cable service. Well, we end up giving everybody in the building reductions in rent, and all that does really, big picture-wise, if you look at it outside that little bubble of the tenant situation, is tell all landlords, don't ever offer your tenants additional services because you'll never be able to take them away. I look at the situation, the question I raised earlier about the tree growing and potentially becoming darker in his apartment. I think that the best way that, if that should happen, is that he would file another rent reduction. The hearing examiner would look at all the case and base it upon the reduction she's already taken, all of that being taken into consideration. It's similar to what probably one of the biggest complaints in I hear about with the Veterans Administration is when a veteran goes in and they have a 10% disability at age 20, they're given a 10% pay because of that 10% disability, but as they get older, that disability grows, and they have to file another hearing to get to the 20% and 30%. And I think that would apply in this case, that if he's 10% reduction in light right now and he claims that 60% later on, that's an argument that the tenant could make. But right now, we're just focused on whether it was a reduction in service or not. And I think the tenant made I think that the hearing examiner made the right decision in terms of deciding that it was a reduction in housing service. I think the question for us is, was the value determined correctly? Because I think the tenant made a compelling argument that there is more value to sunlight than there is to shade. I thought he did anyway. But my main point is just, I try not to focus on what impacts it might have on other tenants. It's this tenant that we have to look at, and it's, he's going to be the one with the reduction or not.
Yeah, thank you, Chair. Well, I'll try to be brief. That I agree with the examiner's determination that this was a housing service, and I like the way that staff provided description and explanation why the examiner's decision was correct. That yes, the natural light and sunlight can be a service, just like I remember cases we heard here where we gave a rent reduction when there was a loss of the shade. Some people like darker rooms, some people like brighter rooms. So here, clearly the tenant is really upset with the lack of sunlight that goes into his unit, and which clearly shows that how important the service was to him. When he rented the unit, there were no trees there, and which means that I presume that when he was looking for an apartment, he was looking for that particular unit, and the unit had no trees in front of his windows, and he would see the sunlight coming through the window to the room, and it's a brighter room, and that's clearly, probably he made the decision to rent the room, maybe also because of that. And if that's correct, so then it's consistent with regulations, section 60041, that provides substantive grounds for a rent adjustment where under section B, it specifically says that a reduction in services affects the tenant of a given rental unit, the relative significance of the reduced service in relation to the safety, health, convenience, and comfort, etc. So in the tenant's argument, it is clearly that's the case, that he believes that his services were significantly reduced, and staff provides an explanation, the importance of natural life to some people, and in this case, particularly to the tenant, and to the point that the beneficial health effects when there is sunlight, there is enough sunlight in your apartment that increases the serotonin and vitamin D, etc., even to that point. So that shows how significant the service is to the tenant. So by considering all that and clearly that is the benefit that the tenant had by renting the room without the trees in front of his apartment. Now with the trees, he doesn't have the same sunlight in his apartment, and now on the top of it, he has to use, he has to spend more, probably, electricity on lighting the room. So I think that the reduction in rent, I want to be short, the reduction in rent is not equivalent to the loss of the service, and I disagree with the $4 rent reduction. I cannot really see analogy with the case where the shade was lost and the same $4 were applied in the rent reduction, because the light, based on what I said, has probably more value here for this particular tenant. So the tenant has to pay more money now for the electricity and et cetera, and the benefit to his health and convenience, comfort, and all other prevailing factors should be used in order to determine the correct value. As I disagree with the examiners on the amount of a rent decrease, and under the ordinance and the regulations, the commission has a right to consider a different amount, and I would like to hear other commissioners if you would agree to maybe come up with a different rent decrease amount here.
A question real fast? Just
I'll put, sorry, question.
the question, yeah. There was also brought up the question of whether the appeal was delivered or can we, what am I saying? There was a question by the tenant whether the appeal by the landlord was done timely and within the guidelines. And I see here that it's not marked on the appeal how it was certified, so I just want to make sure that we are talking about this for a reason. We have a reason to talk about this.
So we do have a proof of service, and the landlord claims that he served the tenant timely. Should be in your packet.
If you look at it on page 14,
Oh, it's not in.
oh, okay. Just to make sure, yeah, please.
Do you mind if I jump in while they're looking for that? Okay. I would vote to affirm the hearing examiner's decision. And our question on the outset is always whether there's substantial evidence to support the hearing examiner's findings. That's our basic first step. And had I been the hearing examiner, I probably would not have found this to even be a substantial reduction. I think the photos are all over the place in terms of the lighting, but what you can see in the photos is that there is light in all of them. I completely understand that light is important to a lot of people and that this, in your opinion, has affected the tenant, but the initial question that we have, I believe that the hearing examiner had substantial evidence to find, as she did. So I think that I would vote to affirm the hearing examiner's decision. I do get what the other commissioners have said about whether this is even a housing service, but I think that we have to defer to the hearing examiner when we find there's substantial evidence, and I think there is enough in the record to agree with what she found.
I'd just note that the housing service question is de novo, so that one we can evaluate on our own.
Commissioner Bergstein?
So in my time on the commission, I can remember two decisions kind of on the flip side. We had one where there was a tree growing literally into the foundation of a building causing structural damage that had to be removed, as Commissioner Kirby's mentioned, where code compliance said this must be removed for structural issues, and the tenant said, I've lost my privacy, I have sunlight beating into my front window, and there was an award for a reduction in housing service. Same thing, we had a small building on Fairfax where the trees were dead and were a fire hazard and a hazard of falling over, and the tenant said the same thing, we now have more sunlight streaming in. So I see where the hearing examiner, where her thought process was on giving a reduction in rent for a loss of housing service. However, when I started reading this packet before I got into the exhibits and the photographs, when I saw, that the trees had reduced the amount of sunlight, I really was expecting to see fairly large landscaping that had been installed or growing in front of a window that would really be blocking the sunlight. Any of you who've been to my home have seen that I have large shrubs that I planted on the eastern side of my property, which does substantially reduce the amount of sunlight coming into that portion of my home. But what I'm seeing in this picture is I don't classify them as trees. These are ferns. These are large, I think they're called an Australian fern, but it's not really a tree. And the tenant freely admitted that this has always been a cave-like unit. I don't know the orientation of the building. I'm going to hazard a guess that there are no windows facing east or west, which normally bring in the most sunlight to a unit. Most buildings that have only a north-south exposure, the best you can hope for is decent indirect lighting, but no direct lighting. So I don't find that these are trees. I don't agree with the hearing examiner that this is a substantial reduction in the housing service. The tenant provided no evidence of any increasing utilities. So I would vote to overturn the hearing examiner's decisions because I don't believe it's a substantial reduction in the housing service. They're ferns.
Commissioner Maggio?
Commissioner Bernstein, I echo his thoughts almost entirely. You know, it's very interesting. These grow very fast and they grow very tall and they fan out. In 5 years, they're going to affect the second floor, and that could become an issue. But I think this is very extreme, and I think the tenant is being very picayunish. And I just cannot agree that this is a substantial loss in any way. These photographs show that there's nothing extreme here. Enough light gets through. So I'm not really going to vote in favor.
It's interesting because I actually tend to agree more with Commissioner Topsy. I'm sorry to be all over the map, but I see that a tenant moved in 2010 in certain conditions, and these are very different conditions, and literally right outside his window. And I do see a value to the sunlight. I also have just a gut feeling that maybe this could have gone a different way had they complained about, you know, trees blocking their view or something, meaning like had the complaints been completely different and not about light, and had they been pushing more towards, you know, the other things we've seen with a loss of a tree, you know, that those damages are higher. So I just have to throw, you know, letting you know what my cards are. I tended to be on more of the side of Commissioner Topshian, where I thought maybe $4 was a little bit too small because it is a significant difference from when they moved in 2010. Commissioner O'Keefe.
I think at this point I would vote against the hearing examiner's decision, both because I don't think that there's a significant, substantial decrease in a housing service, and I'm reluctant to find that there's a housing service in the absence of a tree that partially blocks sunshine. As you know, we're having more and more climate change. I think that finding that the absence of trees is a housing service is a little troubling to me. And any tree grows if it starts small. So does that mean every time a tree grows that somehow it has to be trimmed so that you don't have natural light? I'm troubled by that. And I just, where it only partially blocks the view, I am troubled by the idea of no RSO housing could ever plant trees then if it blocks light at all. I don't know if that's good policy.
My question for those who are questioning the hearing examiner, what is it that she aired, the evidence that she saw, what mistake or error did she make when she reviewed the evidence in front of her?
I think she thought that there was a lot more blockage than there really is. I can't imagine these trees blocking out that much light. They're very fanned. They grow a trunk, and they grow high, and they'll fan out. And Karen brings up a very important part of the environment. We have to take that into consideration. And the oxygen it creates. I mean, all those arguments are important too. And I don't think she looked at any of those elements. And I think it should have been looked at more carefully in that way.
If I may, respectfully, I disagree with that because we have a case before us that specifically relates to this particular unit, this particular tenancy, and the question is this a housing service or not? Yes, and as the chair also mentioned that at the time when the tenant rented, there were no trees, there was a sunlight. That's a housing service, and it's beautifully explained in the staff report. So that is a housing service. absence of the tree. Now, if that's a housing service, the tenant did have that sunlight coming through his windows. So now the condition of the unit is different from the time when he rented. And under the RSO, when we are discussing whether housing service was reduced or not, it's based on what the tenant had before and what the tenant has now. That's what we should consider, not the environment, not the future impact. What is the current impact on the tenancy, and how that this particular situation contributed into his into this reduction of rent application. And as I said, if you look into 60041 regulations, that describes that the significance of the reduced service, and the reduced service is that the lack of same sunlight that he had before planting these trees, and the prevailing market value, etc., but also the safety, health, convenience, and comfort to the tenant, and that is in our regulations. So, examiner didn't err in the determination that this is a housing service, because the examiner, he or she, used this substantive grounds for rent reduction section, I believe. And as I said, the staff beautifully explained why natural light is a housing service, just the same way why shade can be also a housing service. If there's a shade in front of unit and the tree was cut off and now you don't have that shade anymore, you have a light. It's completely the opposite scenario, but it's also a housing service. So that's why there is no doubt in my mind the decision was correct in terms of the determination that this is a housing service. I disagree on the amount of the rent decrease because I disagree on the smaller, and we can go back to the years ago when we established the ad hoc committee to look into the suggested violation guidelines, and I was one of the members of the committee when we decided that we're gonna recommend higher rent decrease amounts, but this is irrelevant, we can discuss it later. But what I'm saying is I disagree with the amount. I understand it's a very subjective approach. I mean, I may use a different amount, Chair may use a completely different amount. So I disagree on the issue of the rent decrease dollar amount, but I totally agree with the examiner's findings. It's a housing service, and I really encourage you commissioners look into that, because we cannot undermine the RSO and regulations that clearly describes what is a housing service, and that's what we cannot change. And I don't believe that the examiner made a mistake in the decision.
An opportunity to look at page 39 and 40. Do you notice how dark the apartment is inside? It's designed to make it look darker. There's no lights inside. 39 and 40, it's a dark room looking out. It's designed to make the room look darker.
Commissioner Bergstein, you have something to say?
So to answer Commissioner Kirby's question, my thought process is that the hearing examiner's subjective review of the evidence presented, her determination was that there's a substantial housing reduction by the placement of this new landscaping in front of the window. When I reviewed the photographs and the evidence in our packet, I don't see a substantial. I still see good natural light coming in, an apartment that the tenant says is a cave-like apartment. So if this had been, I said if at the front of a building, east-facing, bright sunlight, and suddenly there are shrubs growing up blocking the window, that to me is a substantial reduction in housing service. This to me is just a different kind of landscaping. I don't find that these ferns constitute what I would find as a reduction in a housing service.
But you agree with her that that the lighting differential could be a housing service?
Yes, but I don't agree in this instance, but it could be, yes.
So it seems like, commissioners to my right, we have some consensus on this side that possibly we agree with the hearing examiner's decision. I mean, Commissioner Topchian and myself don't agree with the number, but I'm prepared to vote for the resolution to keep the hearing examiner's decision as the decision, because I do believe in the loss of the housing service. I'm just letting you know that I'm not going to stick my stake in the sand and not vote for it because I don't agree with the number, if I can't convince you otherwise. And I haven't proposed a number on, you know, I haven't proposed what number I think it should be. I think that the tenant did make some compelling arguments that if you had thought about this a different way, it could have been a higher number. The only reason, I mean, just to give myself the counter argument that if we were to put in a higher number, it's a permanent rent decrease for a changing situation, which makes me more inclined to affirm the decision, because I do feel that this situation could change with the trees being trimmed or them growing and maybe allowing more light as they get taller. So that's why I'd be inclined to affirm the, you know, the resolution that we have.
And that's why if we come up with the amount of a rent decrease, if the commissioners would, the majority of the commissioners would agree with that, so whatever the amount it will be more above the $4 decrease already determined by the examiner, and that would basically cover the future impact when the tree, you know, would grow, and there would be more shade to the unit. So that
But it's not going to have the same impact. It won't have
The
the same
impact would
impact in a year or 5 years. It's going to affect upstairs then. Look at these 30, 39, and 40. It was taken in a dark room to make it look that it was dark.
And look at the pictures of I'm sorry, page 20. It shows a bright sunlight over there. It's completely different.
To clarify for everybody, they were taken at the direction of the hearing examiner as a comparison to show what it looks like with the lights off, what it looks like with the lights on. They did that intentionally. If you look at the...
No one says they did that intentionally. That is,
No,
they did that to make the outside look brighter and the inside to look darker.
The hearing examiner ordered the inspector to take 4 photographs. It's on page 33 and 34. That's why they're dark and light.
I look at it as a doctored photograph, to be honest with you.
I don't think we should make allegations like that.
I think it's dark. I don't think it was taken correctly.
I'm just going to go ahead and test the waters here, because we have deliberated.
Before you
for
do
a while.
that,
Oh, yeah, sure.
yeah, I'm going to jump in and say I've actually been swayed by Commissioner Bergstein and the people to your left that this was a substantial reduction. So my vote would be that we would overturn this based on the comments we've heard today and then re-reviewing the photos.
That this was not a substantial reduction?
Correct.
Okay.
Not a substantial. And, you know, in that, we have, you know, 4 commissioners now that look like they want to overturn this. It's not being a substantial reduction. So we would remand this back to the hearing examiner, or we'd simply just overturn this and it's not a substantial reduction and...
Right, just make a motion.
Are we, I mean, I'm not quite sure if we're ready for a motion, because, I mean, maybe we are. Maybe I'm the only one that feels like we haven't really made a solid argument. I mean, everyone has kind of given an argument, but I don't understand how we're going to sit as a commission, and because the question before us, we're not supposed to reweigh the evidence. But what we can do in this case, the de novo, and correct me if I'm wrong, if I'm misunderstanding which part we can do the de novo on, but whether it's a service or not, it seems like we all agree, or at least a majority of us agree, that it could be a service. You're right, you're pretty much against it at all. And if we believe that, then I think, if we believe that it could be a substantial decrease, then I think that we need to figure out where the hearing examiner erred in her decision on reviewing the evidence. If we can't do that, then we need to stick with her on the evidence. And then the separate issue, I agree that I think the tenant made a compelling argument to look at that as a separate question, the value, and see if she erred there. Maybe she didn't use the right analogy. And we can look, we've done that before, we've looked at the regulations, the guidelines, and said, well, this is more fitting because of the 2 lamps, blah, blah, blah. But right now, I think that it's hard for me to understand how the commission could decide that something that we know can be a service and the hearing examiner determined it was a service, how we're going to overrule that. And I know that you have pretty much been against it. You don't believe it is a service. So I'd like to hear from like the other
Who are you
five.
saying that to?
I'm sorry, Commissioner O'Keefe.
Okay, you're looking at a lot of people. Okay.
I'm going to go ahead and make a motion that on hearing examiner's decision D-4357, 1216 North Crescent Heights Boulevard, unit number 16, that we reverse the hearing examiner's decision. Did I correctly word that, Ms. Regan?
Yes.
Thank you.
I second the motion.
We have to have conclusions of fact and conclusions of law in our alternate resolution, do we not? Do we need to say something more, or can we write it up next?
You have a discussion after the second, if you want
Oh.
further discussion.
I'm just, for procedural reasons, I'm wondering if legally this is sufficient, or if we need to have reasons also.
Well, if you're reversing the hearing examiner's decision, are you finding that there was not a substantial reduction of a housing service? If you're finding that this can never be a housing service, then that needs to be articulated.
So perhaps could I amend the motion that I made to reflect that we do not find this to be a substantial reduction in housing services in this particular instance?
Yes.
Would that clarify that?
Absolutely.
I'll second that.
So we do have a motion on the table. Secretary Barino, can you please call the vote?
Commissioner O'Keefe?
We don't get to talk about this?
Oh, I mean,
This is a very specific, I think I find problems with this resolution. I would like to know what the resolution is going to say when it comes back to us under this motion, because this motion doesn't describe how she erred. It just denies it, right?
No, Commissioner Bergstein just said that we would be making a finding that it was not a substantial reduction of a housing service, period.
yeah.
So then will the resolution not have to say why?
That's already
Ms.
saying why.
Regan?
Yeah, I mean,
It's the examiner's decision, it is a housing service. Now, if we're saying.
Oh, no, you're not, what you're saying, that is how what you're saying, that's how the way I understand the motion to be, the error is that she found there was a substantial reduction, and you're saying, no, in fact, there is no substantial reduction. The evidence does not support a finding of a substantial reduction of housing service.
Secretary Barino?
Commissioner O'Keefe?
Aye.
Commissioner Kerpes?
No.
Commissioner Maggio?
Aye.
Commissioner Martz?
Aye.
Commissioner Topchian?
No.
Vice Chair Bergstein?
Aye.
Chair Charity?
No. Well, thank you, commissioners. Thank you, parties. If you have any questions, please refer to staff. As always, in landlord-tenant disputes, we always encourage you to please try to find some common ground here and a way to live together. I realize that tensions are high, and if we can find some way to make both parties happy here, that is always in the best interest of everybody in our city.
Do we have to address the second appeal, or does that encompass both? Is that, it pretty much satisfies the second appeal?
This is both.
Okay.
So,
I call for a 3-minute recess.
yes, take a recess. Okay, thank you. We're coming back from recess. Moving on from our item 9 to item 10, new business. In our amended agenda, we've moved item 10B up, and we do have a speaker on item 10B, so I believe we hear that speaker first, Mr. Ted Green.
Do we have a staff report or no?
Oh, yes, we probably do. Sorry about that.
I don't know if we do
I don't
necessarily.
think we do, yeah. None, no. So we do not have a staff report, so Mr. Ted Green, thank you.
Is Ms. Regan not going to return for this? I think we
Okay.
should probably
You
wait for
wanna
Ms.
wait?
Regan on
Okay.
this one, yeah.
Sorry, Mr. Green. No, thanks, Josh. Thank you. So at this time, we'll have our public comment on item 10B from Mr. Ted Green.
Sunset Boulevard are a client of mine. I appreciated you calling my name at the beginning of the meeting, but I was excited to finally have an agenda item to speak on specifically. That's a little bit of progress. Having said that, I'm astonished that there's neither a staff report on this issue, or a written staff report with information on the zone text amendment, the impacts of the zone text amendment, the reasoning behind the zone text amendment, nor is someone from the planning department here to explain the zone text amendment to you. It was interesting in looking at the agenda for your meeting yesterday online. At the beginning of the day, what was posted was your March 14th agenda, but then for a little while there was an interim agenda posted that had some deletions, and what was considered there, I guess by the staff, was to delay this item until April 25th and having the planning department make a presentation to you. I see on the agenda in the back of the room that's now gone, and what the staff is saying is that you could consider making a request to the city council to weigh in on this item. You know, again, if you look at the municipal code, one of the purposes of this commission outlined of the 4 is the commission shall evaluate and make recommendations to the city council relative to the city's housing policies. I don't understand why staff is so reluctant to hear your opinion and incorporate your opinion into what they are proposing to the city council as the municipal code calls for. And finally, on the issue itself, this idea that requiring one-year minimum leases on apartments built after 2001 has no impact on rent-stabilized units, that seems preposterous to me. Because if you think about it, whatever demand exists for flexible lease apartments, apartment leases between 1 month and 1 year, whatever that demand is, if you say that demand cannot be served by apartments built after 2001, that demand doesn't go away. It's going to be forced to apartments built before 2001. And over time, as newer apartments are built and are not allowed to serve that demand, that means it's a smaller and smaller percentage of apartments that demand will go towards. So there's no question that this has a direct impact on rent-stabilized units in our city. Your commission ought to have a full presentation and discussion and share your opinions. Thank you.
Thank you, Mr. Green. And we will deliberate this. Just to address some of your immediate concerns, we did push this up on our agenda and not wait for the presentations or the staff because we thought it was important to discuss amongst ourselves. So we do have some of those things coming, but we wanted to get a jump on this actually and start talking about it.
I do need to sort of inform the commission of how this needs to happen procedurally. Because this is not in the purview of the Rent Stabilization Commission, zone text amendments are formally presented to the Planning Commission, who has to either approve or disapprove, and then they go to the City Council. The group can discuss this issue amongst yourselves if you would like to. If the commission decides to take some kind of a formal position as a commission, before you do that, you would need to make a request of the City Council. So if this ends up to be just a discussion to sort of discuss what the issue is without taking a formal position, then that would be fine. If you decide to go further than that, then we'll have to take some interim steps.
I have a question. Ms. Regan, how do you, with what you just said, how would you compare that to when earlier this year the Public Safety Commission took actually took an opposite position on a piece of legislation that the council had already taken a position on? How did that become official?
I have no idea.
Okay, so it does happen.
Well, not in this context. So this is a zone text amendment that through our ordinance has to first go to the Planning Commission and then it goes to the City Council. So there's a process, and if the Rent Stabilization Commission wants to weigh in on that, they first have to get permission from the City Council to do that.
Where does the West Hollywood Chamber of Commerce come into that procedure?
I don't know.
So, Ms. Regan, whatever we discuss now, if it's on the agenda, we can brainstorm, we can talk about it, but we cannot make any recommendation, nothing. So what would be, okay, so what we're going to do, just receive and file, or, excuse me.
Sure, you could do that. Absolutely, yes.
And the provision of the West Hollywood City Code. My mic's not on. Advising on housing policy, how does that come in? It's just not really applicable unless we have the council's permission?
No, I mean, it would depend on the context. So, for instance, if staff is proposing some kind of an ordinance change that relates to housing policy, then that would perhaps be appropriate to come before the Planning Commission. This is a particular process that has a mandated procedure in the code, and so this would be a deviation from that procedure in this specific instance. So there's sort of the general umbrella of how, and then there are these more specific procedures that require different applications.
This may change the zoning ordinance, current zoning ordinance, and it's not within the purview of the Rent Stabilization Commission. So whatever, you're absolutely right, commissioners. When years ago the City Council included in the ordinance that we, in the Muni Code, that the Commission, Rent Stabilization Commission, can discuss issues related to housing, but it's within the purview of the Housing Rent Stabilization Commission in regards to the Rent Stabilization Ordinance. So we cannot really, I believe, as Ms. Regan explained, we cannot really recommend any changes to the zoning ordinance.
So I would like to, not yet, because I would actually like to discuss the policy
Right.
itself, even if that's all we're doing is saying our own opinions without the benefit of a staff report or the actual language, which certainly limits how informed our conversation can be. But I would like to later on propose, and for us to think about, asking the council if in the future, not only in this case, but in any zoning text amendments that affect housing policy, that we have the opportunity to weigh in before the decision goes to council.
I can just briefly weigh in that the procedure, as I understand it, because we've had two issues where we have taken action at the commission level, and all that we can do is come to council and say, this is an issue we would appreciate if council would weigh on, and there is a subcommittee consisting of the mayor and the mayor pro tem, and they are the ones that determine any actions coming from any of the boards or commissions, whether further action will be directed to staff or taken by council. So it's sort of we can talk about things to council if we feel this is important, but it's up to that particular subcommittee, and that subcommittee changes every year as the mayor and mayor pro tem rotate. So it is a process. I kind of want to echo that as the information that we currently have, council seems to be discussing, would not have a direct or significant impact on rent-stabilized units due to the year cutoff. Perhaps there might be some mobility on rent-stabilized units being more in demand for shorter term. And I'm not sure how I want to see this play out with council. I'm not, and this is my opinion, that a one-year lease, a mandatory one-year lease, is required, but there needs to be some balance to protect our housing stock from short-term rentals. We already have a ban on short-term rentals, which I think are under 28 days, unless it's an owner-occupied condominium with the agreement of the association, or a home where the owner is there. So I think we're pretty tight on that. But I think there might be some leeway in there somewhere where it's not a one-year mandatory lease, but some kind of a definition of what length the leases should be. I know I've heard comments before. It hadn't dawned on me that, what if a homeowner or a condo owner sells their unit and their new place isn't quite ready? They want to lease back what will become their former residence for 2 weeks while they're packing up. Would there be an exception to whatever council has decided to say, oh, if you're an owner vacating your premises, under that circumstance, would that be a short-term allowed? So I think there's a lot of questions that could come up at council discussion, and I think that council always has the option, if they so choose, to sort of remand this back to our commission. If they were to say, we're not quite ready to make our decision, we'd like to hear what rent stabilization has to say. They certainly did that with the earthquake retrofitting, where before they made their decision, they wanted a very thorough process through our commission, our report to them to help them form theirs. So the council always has that option of saying, we'd like to kind of send it back to your commission. We'd like to hear your thoughts formally. So I'm not sure where I stand. I kind of, maybe I'm on a tangent, but I have also been kind of in favor of corporate housing. The newer buildings on the east side, when Oprah moved into the lot, that, what if her executives need to stay someplace for 3 or 6 months? It's a separate issue, but so I think there is some leeway in there somewhere on defining what is short term and what is the shortest term that we would allow. I'll be interested to see council's discussion on that and where they move forward with it.
Chair. I just want to, I'm a little bit confused with the whole idea of discussing and proposing something to this proposed change in the zoning regarding the one-year lease requirement. So I understand the benefit for kind of a newer properties or condos or whatever the rentals, not the condos, newer constructions, newer units, non-rent control units, I understand the benefit of it. So if you require at least 1 year lease, you guarantee that that tenancy is going to be protected. It's going to be protected, yes, in terms of the rent level and all other terms and conditions. We're locked within at least the minimum 1 year. What's going to happen after 1 year? That's not something we want to talk about. But for rent control apartments, rent stabilized units, I don't understand the value of requiring the 1 year, at least minimum 1 year lease, or what's the purpose of it? Because under the ordinance, you don't even have to sign any lease. You are not required to sign any document. You can give a check to the landlord on day one for 1 month rent, and you're a tenant. And with all the protections that the RSO provides, with all the terms and conditions initially discussed with the landlord. If you have a written lease, doesn't matter for whether it's a 30 days or 6 months or 1 year, it's irrelevant. Because anytime you pay the first month rent, when the lease term ends, if it's a written lease, obviously we know the tenancy will go month to month with all the terms and conditions, with all the protections. So what's the point of discussing about the importance of the 1 year lease for rent stabilized units? I don't see any, because the rent stabilization ordinance already provides that benefit, the highest protection you can even think of. Because that's why I'm confused, or maybe I'm not understanding something.
I think that the ordinance that's being proposed, which I don't know if it's even drafted yet, is only for rental units approved after May 1st, 2001, so it would not apply to rent-stabilized units. It would only be for newer ones. Staff, do you know if that's correct? I know there's no formal report.
The date is 2001, yeah.
Yeah, so, but to me, the relevance isn't for rent-stabilized units. It's that I think that our commission's purview includes opining on housing in general.
So post 78 units, we're talking about the after 78?
Only after 2001, so it's only newer units.
But these are not rent stabilized units.
Correct.
So I'm thinking as a rent stabilization commissioner, so what is the necessity for me as a rent stabilization commissioner to look into that importance to me as a rent stabilization commissioner to review and to suggest, to recommend anything for that zoning ordinance that is completely irrelevant to the units that I am dealing with. So as a community member, if I'm concerned about it, I'm going to talk to the council person or council persons and express my thoughts and my ideas. I may go to the council meeting and speak in the public comments, but I don't believe that our commission should take any position or any recommendation if it doesn't apply to the rent-stabilized units that we are dealing with. So that's just my position.
I have to agree with Commissioner Topshin. I feel this is legislative work, and I think our main duty is to be adjudicators. And I do not know anything about zoning, and so I don't feel really qualified to really almost have the to really make any statements here. I feel I would just have to listen and learn, and that's important as well, but I think this is legislative work, and I don't think that's our job.
Mr. Commissioner Kirby.
So there are two people on the commission that have been pushing this, and I've been pushing this for a long time to have this discussion. The planning department denied our request through Mr. Noonan to come and do a presentation. The reason this is on the agenda tonight is because Commissioner O'Keefe decided to move forward, which I very much support, in bringing this to an agenda item without a full discussion. So I would like to give, before I just jump in, and I know that you haven't spoken at all, and I really apologize, but I think that either she or I should really kind of set the stage for why this is even in front of us. So I'd first like, if that's all right. So before I answer the specific questions that have come up, I just want to say that my goal for bringing this to our discussion is not so that we can establish policy, set a zone text amendment, or support it, or oppose it. We don't have the information to do that. It's just us here. And I can't say that I know it, and I know that I've read all 3 staff reports on it. So that's not what this conversation is about. This conversation is about the underlying responsibility of this commission. And I know Commissioner Maggio disagrees. He's always disagreed with me on this. But the fact is that in our ordinance, not our bylaws, it's more important than our bylaws, it's ordinance, and we shall, not you get to, not you can, you shall, no, I will read it directly. It's basically, I'm going to have to read it directly because I just said that. So I will read it once just for the point of being that, and this is the municipal code, and it is in my binder. 2.64090. It's the duties of the Rent Stabilization Commission. And I'll go through all 4 of them, but we'll focus on the 4th one. The duties and responsibilities of the commission shall include the following. 1, the commission shall be responsible for promulgating policies, rules, forms, or regulations found necessary to effectuate, implement, and enforce the provision of this chapter. Regulations, policies, and rules promulgated by the commission shall become final 45 days after recommendation to the council unless rejected, modified, or sooner approved by the council. Fees shall be established by the resolution of the city council, period. Number 2, the commission shall hear all appeals of decisions by a hearing examiner, period. 3, the commission shall submit an annual written report to the city council describing its activities taken pursuant to the provisions of this chapter, period. 4, the commission shall evaluate and make recommendations to the city council relative to the city's housing policies. It says nothing in there in number 4 about rent stabilization. If it was specific to rent stabilization, it would do like number 1 did, where it says we must promulgate policies, rules, forms, or regulations found necessary to effectuate, implement, and enforce the provisions of this chapter. It's a very separate, on its own. It's when the city was founded. It was one of the first ordinances the city passed. They have not changed that. We can debate, which we always do at every staff retreat, we debate whether that's part of our rules or not. We can continue that debate, but not until the council changes it. It's fact. The commission shall evaluate and make recommendations to the city council relative to the city's housing policies, which is the reason why I think it's so important. It's a struggle for me to think of anything more relevant to this commission than what is in a person's lease, which is the foundation of a tenancy in the city. So that is why I wanted us to come to this commission. In an ideal world, we would have had experts in front of us telling us what the proposal is and why they based upon on what evidence or reasons they based their proposition or proposal on, but we don't have that. So I think we should make the record very clear that our recommendations or any comments that come out of this tonight are to the council are based on not having evidence, that we are just based upon our own personal knowledge, our own personal understandings, but we are still coming together as a commission to come up with these comments about a policy that will affect housing in this city. The way it affects housing, the rent stabilization units, is that we have X amount of rent stabilized units in this city. These will not directly be affected by this change overnight. None of these are excluded. If you live in a rent stabilized unit, or if you own, I should say, a rent stabilized unit, you can offer a tenant under the current law anywhere over a 31 days to whatever, any amount of lease. If I were a landlord and I went to the counter tomorrow at City Hall, they would not advise me that I could not do that legally. They could not point to the ordinance to say, you cannot give a 6-month lease out or a 9-month lease out. This rule They randomly chose, they didn't randomly choose 2001. They chose it based upon, that's the first mention of, I think, dwelling, or they based it on because of another reference in our ordinance. To me, that's not good enough. This is a policy change that's going to say that anything built after 2001, you must offer people a one-year lease minimum. If I'm coming to the city and I don't want a one-year lease, I'm looking for a 6-month or a 3-month or a 9-month, I'm going to be excluded from those buildings built after 2001. Sure, there are some buildings between 1978 and 2001 that aren't rent stabilized, but very few. If you look at the amount of units built in those years, very few. So a majority of the units in our housing stock are rent stabilized. There's going to be a pressure put on those. Those are going to be filled by these 3-month, 6-month, 9-month tenants. That means that there's going to be a higher likelihood that those units will turn over quicker than the units across our city. Because of Costa-Hawkins, anytime a unit crosses over, and we all know this, or turns over, the rents go up to market. So we essentially lose our affordable stock of housing at a faster rate. We're not going to lose it overnight, but we will lose it at a faster rate than we do without this law. That's just based on logic. I'm not based on anything else other than just common logic and reasoning. These are issues that we should care about. These are issues that we should be commenting about. I'm not for or against 1 year. I don't know, other than I don't know many people who want a 3, 6, 9-month lease. I've only been offered maybe a less than 1 year lease one time in my entire life in all the rentals I've been. I don't think it's going to happen often, but I don't know every situation. With young people coming here, if they want to be responsible and they don't know how long they're going to be able to stay here, they want to find a roommate before they really settle in, they could come here for a short while, 3 to 6, 9 months, find a place, and then decide that they have enough money to find a roommate that they like, and they can move into a 2-bedroom, for a 1-year plus lease. There's so many situations that we don't know about that we would be precluding from coming to this city. If you read the staff report that was written, drafted for the city council when this was supposed to go in front of the city council back in, I want to say January, they make, the authors of the report make it sound like it's going to be horrible circumstances in this city if we don't put this 1-year rule in for these 2001 to present buildings. That makes no sense to me, because the places we really want to protect are our rent stabilized units. So under their logic, we should apply this across the board. I'm not advocating for that. I don't know if that'd be a good idea, but if you read their logic in their staff report, that's what I interpret, is that they're protecting from these bad actors new buildings, but not our rent stabilized units that we really need to protect. We don't need to be protecting the $3,000, $4,000 a month rents. The last thing I'll say about process, I adamantly, and Ms. Regan and I discussed this yesterday on the phone, I have so much respect for her and the city attorney's office. I think that they are dead wrong on this. Like I said, I can't think of any other thing that is more directly related to housing policy is changing leases. But in terms of process, there's nothing that I've asked for, and doing a presentation and whatever our comments might be, we have no authority to change the law in this area. So I don't see how our participation in dialogue as a commission is going to affect the current policy that they are, or the current procedure they are following. We've had plenty of time from the Planning Commission to the unknown date of when it goes to council. We've had plenty of time. I've been asking for this for 3 months. If you look in the staff report from the Planning Department, says West Hollywood Chamber of Commerce Government Affairs Committee. They asked for government in all their staff reports. It says, "What did you do for the community outreach?" The community outreach they list on all of their staff reports all the way through is city staff presented this item to the Government Affairs Committee of the West Hollywood Chamber of Commerce on January 8, 2019, at their regularly scheduled meeting where members provided staff with feedback on this item. Members expressed concern regarding the requirement for 1 year on dwelling units, but were positive about the shift to development permit approval as the threshold. Ultimately, the West Hollywood Chamber of Commerce presented a recommendation of denial to the Planning Commission. Then it goes on. There's a paragraph. I don't understand why the West Hollywood Chamber of Commerce, as important as they are, they get a one-on-one FaceTime session, get to have a dialogue with the planning department, but the planning department can't come to the Rent Stabilization Commission that shall make recommendations on city housing policy. That to me is absurd. So I guess I'll just end there. I'm sorry that I've talked for so long, but my goal is not to take a position unless we feel strongly that we want to take a position. I just don't think we have enough information, and I think that the city is doing, I think that all people are doing a disservice to the city council by not allowing us the information and the presentation that they've afforded to the West Hollywood Chamber. Thank you.
Thank you so much, Commissioner Kerpes. I just want to share with the commission that I wouldn't be interested as much in the issue unless the council member that appointed me asked me what I thought about it. It seems that he also respects that we do have a say in housing policy in West Hollywood, and I just want to add that I am very moved by our speaker and also Commissioner Kerpes' comments that demand does not operate in a vacuum, and if we're taking a large portion of our housing stock out of the short-term rental market, it's going to appear somewhere else, and I am moved by the argument that it could appear in our rent-stabilized housing, which concerns me because you could have landlords that are holding out for only applicants that are short-term.
You mean for rent control units as short-term?
Yeah.
But it's not possible. I don't see how it's technically possible. So there is no
Well, I guess
nothing that says that the owner can execute a 3-month lease for rent-stabilized unit, and after that 3 months, the tenant has to move. The tenant doesn't have to move. If the tenant
doesn't have to move, but I guess my question is, if you are a landlord and you have one applicant that says, I'm only in town for 3 to 6 months for a job, and you have one applicant that says, I'm here permanently, I want to live here for a long time, you may have a preference for the shorter term applicant, so you can turn that unit over faster.
But if we're gonna include, and I hope that's not gonna happen, if we will include rent stabilized units in 1 year lease zone tax amendment, which I believe is not gonna happen, but even if, let's say in a hypothetical, even if that happens, so we're gonna invalidate basically all non-written agreements to move into the unit. We're going to say you didn't sign a 1-year lease, so your tenancy doesn't exist. So we are opening a Pandora box. This is going to be very dangerous for rent-stabilized units. So commissioners, you need to realize that if we're going to take any position on this, that will change drastically the initial way the ordinance was drafted, that it doesn't matter, you have a lease, you don't have a lease, you pay your rent, you're a tenant, and your tenancy continues month to month, as long as you stay there for 30 days or more. So now, if you require that it's going to be at least 1-year lease, so you're basically invalidating thousands of tenancies, rental agreements here in the city. So it's a very dangerous area that you want to step in. And I would suggest, first, let's carefully review. I have nothing against basically receiving information, as Commissioner Kerpes explained. Nothing against to receive the information, to discuss it, or maybe to talk to the council person who appointed me, or maybe to talk to the city attorney office staff. It's okay to gather that information, but to propose that we should include the rent stabilized units in this amendment, it's a very dangerous thing you are going to propose, and trust me, it's not going to be even considered.
I'm not going that far. I'm saying maybe we can make a recommendation to oppose the amendment in general. I'm not saying include rent stabilized units. I'm saying we can make a recommendation that we don't want to have this mandated 1-year lease, initial lease. So I'm not going that direction. And I also just want to share with the commission that in meeting and talking with my council member about this, that their call on this was they think it's going to be a 3-2 vote approving this amendment. So I just think that I just want you to know that they see it as a very real possibility that this will become law based on their gut check of the other council members that they sit with, that it is looking like a 3-2 vote approving it.
My one thing is that we, as the rent stabilized commissioners, we cannot take any action or suggest any possible outcome that will undermine the RSO. So that's going to be a completely irresponsible thing to do. That's my, my thought, my message.
I just want to say, I don't think I've heard anyone suggest that. I think the only suggestions I've heard are perhaps we might want to consider, if we had heard more information, a suggestion that maybe we would oppose the resolution as drafted and that the logic that applies to it could arguably apply to all units as well. I don't think there's, unless I'm missing something, I don't think anybody's voiced any desire to do what you're suggesting. And on the merits of the issue, again, I agree with everything that Commissioner Kirby's and Commissioner Charity have said. I haven't had a chance to read the staff reports. We didn't have anything in our own packet. I do very much think that number 4 bullet on what our duties are, this is clearly, I think, within our duties. This does not just say rent stabilized housing, it's all housing. So I'm very disappointed that we aren't given the opportunity to make a formal recommendation after hearing all the evidence before a decision is made, because I think if the council didn't want us to opine on housing policies, they should not have included that, and since they did include it, I think we have a responsibility to consider and opine on it. On the merits themselves, not having looked at it too much, I think there's a diversity of needs for housing. There's some people who come into town short-term for an internship or for work, or they might be a student that's only planning to stay during the school year, and I think if you close out, it's just not practical to completely close out that portion of demand. And I don't see why anyone would want to. And if they were going to, I don't see a sound policy reason to close out only the newest of housing. As Commissioner Kirby said, that will simply drive that demand to the housing that's the most important to keep affordable and to have available for rent-stabilized units. I personally have had shorter-term housing multiple times. When I was a student, I had 2 9-month leases while I was a student, so I could travel. I had 1 6-month lease. We knew somebody who was friends with my husband who moved into town and had a job lined up, but the costs of housing are so high that she ended up homeless for some time. And part of the problem is if you have to sign a 12-month lease, you need first and last month's rent. So for the most vulnerable members of communities, it can be important to have the option of having a shorter-term lease. So I personally, at this stage, wouldn't be supportive. I don't know what's led to it being proposed. I haven't been following that closely. I wonder if whatever is the reasoning could be addressed more narrowly, such as saying only 10% or 15% or whatever percent of any building's units can be short-term if the concern's having a building be entirely short-term, or if there otherwise could be some creative solution. But I think outright banning any shorter-term lease from any portion of housing, at this point I think it's misguided, although maybe I would feel differently if I heard more evidence.
I will be brief. I think Commissioner Kirby's makes a good point that this is within our purview to look at housing policy and things that affect the housing stock within our city. I think we also owe it to members of the public, like Mr. Green, who bring concerns and questions to us, especially multiple times where we haven't answered it. If it is within our purview or potentially within our purview, that we respond to the public. We're not just here in a vacuum. We are a public body, and I think that's important to always remember that these public comments are there not just for people to spend 3 minutes talking at us, but for us to actually absorb what they're discussing. And briefly on the merits, I've done landlord-tenant law, I've done housing law for quite a while now. I don't see the benefit of this law for the city of West Hollywood for rent stabilization. I think without looking at it specifically, the broad view is that this is a solution in search of a problem. In all of the landlord-tenant cases I've prosecuted and I've handled, this is not the issue that comes up to protect our tenants and to protect the landlords that are doing right. So I think that this would create unforeseen problems in our city, and I would echo the value in some cases of a 3-month, 6-month, 9-month lease, which I've had myself. So without looking at this specific proposal, I don't like the idea of a mandatory 1-year lease on a good chunk of our housing stock.
So the question is, commissioners, do we have any consensus to ask city council to bring this to our attention? And that's, you know, I can see 3 of us for sure do, maybe 4 of us, but that would be what our action would be tonight, to make a request of city council that we have a say on this. Now, I know your position, Josh, that we definitely have a say on it because it's in the West Hollywood Municipal Code, and I agree with you, but just going from, you know, what our council said tonight, I would like to have a formal opinion that was, you know, greenlit by city council so we could have it say.
I'm not opposed to that. I mean, it's not my ideal. Well, actually, I mean, considering the circumstances, it would be ideal that it come back to us with experts to tell us the reasoning for the basis for their proposal. So I'm okay with that. What I fear is that this has been pushed and pushed and pushed and pushed and pushed, and we know that the council's going to get it. So I would like to move forward with a request that the council allow us to ask us for our opinion formally, but in the meantime, knowing, and like I said from the very beginning, stating clearly for the record that we are of limited knowledge on this. There have been 3 or 4 members who have kind of fleshed it out and kind of said what they thought about, there goes my microphone, what their gut feelings are about it, based upon the little bit that we know. So at least the council has that going forward. And it kind of, I think it shows that it supports our request and the sincerity in our request for why this is so important to us.
I'm just going to jump in and counsel strongly against that, and for a couple of reasons. You've all acknowledged that you have not had the benefit of any kind of formal presentations, any kind of formal testimony by any of the experts on this issue. And much like when you're sitting on a jury, they counsel against taking a vote before you've actually deliberated. So it's much easier to change your position or to come to a different viewpoint if you haven't established your position already without acknowledging, without having any limited knowledge. The second reason I would counsel against that is you don't want to predispose the city council to what you may or may not do. All you're doing tonight is requesting that the city council give you an opportunity to make a full and complete opinion about this particular issue with all of the information that all of the other bodies have had the benefit of.
2 bodies, right? Planning and council.
Yeah,
All right.
didn't mean to imply there were 1,000.
All right. Look, I'm going to reiterate, I just do not know enough about the topic. I've not had a discussion with my city council member. I'm not opposed to this discussion in depth, but again, unless the experts come in front of us and educate us, I mean, how could, it just wouldn't make any sense to talk about something or give opinions on something you really, I'm going to use the personal pronoun, that I do not know anything about.
Can I propose a motion, and Ms. Regan, help me with the language that you just spoke of, that we move to request of council that we be given the opportunity, and help me out here, for a full presentation. How did you word that? Because that's what I want to say.
Yeah, to formally
Request of
weigh
council.
in on the issue of the zone text amendment.
And just to make a friendly amendment, I'd like that request to include citing West Hollywood Municipal Code, that it's in the purview of the Rent Stabilization Commission to have an opinion about housing policy in this city.
Okay, yeah.
I just want council to see that.
So your position is that the opinion of the Rent Stabilization Commission is that it falls within your authority to weigh in on issues that touch on housing policies. You are, as a body, are of the opinion that this zone text amendment falls within that purview, and therefore you're requesting that City Council make a formal, approve formally your ability to voice an opinion on this particular issue.
I would accept that friendly amendment, yeah.
and I think I like the language of after a full presentation. I think that we should include something about that, about having a presentation with a staff report and someone from planning, if that's all right with you.
This is going to be done orally, and we'll pull it from the tape.
Like,
So, yeah.
And I second that motion.
I would go along with this, I mean, I will go along with this motion just to, as a compromise, but I think it's ridiculous to be ordered to do something, but then to ask that authority to okay that we're doing it on their behalf. I think that's a little odd, and I think that I would like to see I won't even try to amend the motion, but I'm just put it out there that I think that the motion should be not asking for permission, but to make it clear that the commission wants to fulfill its duties, and that I won't go this far, but that we don't have to do this every single time we want to comment on something. That is ridiculous.
And maybe that's what we do if we get denied.
Yeah.
Thank you. So, Secretary Brino, may we have the vote?
Commissioner O'Keefe.
Aye.
Commissioner Kerpes.
Aye.
Commissioner Maggio.
Aye.
Commissioner Martz.
Aye.
Commissioner Topchian.
No.
Vice Chair Bergstein.
Aye.
Chair Charity.
Aye. Thank you very much. We can move on from item 10B to item 10A. We're going to talk about the discussion of forming subcommittee to review rent stabilization ordinance and rent regulations. I believe this was a Commissioner Karen O'Keefe item.
It was, thank you. Last meeting, we had a couple of court cases that were brought up in one of the appeals, and it made me think that it might be worth having a subcommittee just pour through the rent stabilization ordinance, which I guess we don't have the authority to change, but hopefully under our duties number 4, we have the authority to recommend changes to see if there's anything that perhaps should be tweaked to make sure it's consistent with court decisions and also with state statute. For example, one of the NOI provisions refers to how much money can be paid or considered paid for time spent by the landlord or their contractors, and the amounts are below minimum wage now because state law has changed. So I just thought it might be worth having a formal process where we look, make sure there's the issue of that 1991 investments where they found that it was okay to use concrete instead of carpet, and yet the rent stabilization ordinance itself says that carpet has to be replaced every 7 years. So those are just the things that I saw last 2 weeks ago and that come to mind, but I think it's worth having a group of people with assistance of council pour through and just see, the city council itself is supposed to look over by its terms the rent stabilization ordinance every year, but I doubt it comprehensively happens, and we're the people that deal with it day to day. So, of course, any recommendations would go back to the whole commission and then to the whole council, but I wanted to propose that. Care really much if it's ad hoc or if it's standing. I think it would require approval either way. So standing would be it could just meet every time there's a new decision, or once a year or so to make sure there's nothing that needed changing. Ad hoc would just be now essentially or soon to look over the ordinance with the most recent court decisions and state law and just see if anything looks like it might need changing.
Oh, sorry. It's so loud today for some reason.
So you,
about that.
you want us to, go ahead, Delegacy.
Commissioner, all right. Just one very quick one. In the past, the commission had ad hoc committees or subcommittees to review certain parts of the ordinance and recommend, or the regulations to recommend changes or amendments, etc. I was a part of a few years ago, a part of the committee that reviewed suggested valuation guidelines because the commission believed that the guidelines were below what reasonably the examiners could have used the amounts for the rent reductions. As a result of that work, that the former Commissioner Gail Sands was part of that committee, and myself, we made some recommendations and changes to the regulations, and particularly tonight I referenced the regulations section 60041 That was also as part of the amendment, and the guidelines were increased, etc. And we also looked into the relocation assistance fees that were increased, and we recommended to the City Council. Those are the changes that I remember now. And I believe there were some other things also the staff recommended, and we'll look into that. So I like the idea. I'm not against it, and I would like to join the committee or ad hoc committee. But I don't understand what is going to be, how it's technically going to be, what is technically is going to happen. Are we going to review the entire ordinance and all regulations, and we're going to start looking into every sentence, every provision, every section? Are we going to start changing and amending things that we believe should be otherwise written or suggested? So I strongly recommend whatever we're going to decide, we have to keep in mind whatever decision we take, it's going to have a huge impact on the tenants and the landlords. And another thing is that our ordinance also, I know that any changes we do, we always look into the other rent stabilized jurisdictions, how City LA ordinance works on that particular issue, Berkeley or some other jurisdictions. So we cannot just decide, I disagree with this, so let's go and change it, and we'll get the 4 votes and we'll change it. So it's going to have a very dangerous, maybe, impact. So we have to be very careful. And I don't recommend that we just start looking through the entire ordinance and the regulations, page by page, section by section, decide what's working, what's not. So we should have a specific, particular maybe area that we disagree based on our recent reviews of the appeals, and say, okay, so this particular thing that we believe should be looked into and maybe recommended to be amended, but not the entire ordinance, not the entire regulations. So that's what I wanted to say.
Well, how do you select that then? I mean, it seems to me that it would be okay to look at everything. It's a lot of work.
Yeah, we
there's
cannot
no doubt.
rewrite the ordinance. We cannot rewrite the regulations.
Oh, but there's
so we
no
can't.
reason why one can't review and to look at maybe an ordinance that could be maybe perfected or tweaked in some way. I think if you're going to do this type of work, I think you really have to do it all. You just can't pick and choose. It's all important.
Seems like, we all can at any time right now, if I say, let's discuss changing 60008 applicant withdrawals, well, that's probably ordinance, maybe not, but something else in the regulations, I could do that, and if we had a majority, we could do. This, I think, is proposing a more systematic way of dealing with that. So instead of just bringing something right to the board, the commission, on a specific item, we would say, hey, can we have the committee look at this item? And then the committee would focus on that item. As we all look through the ordinance at any time, I mean, there's always things I'm kind of making a list of that I have questions about, or...
It seems like I'm a minority today, but that's fine. So what I'm trying to say is that what is it specifically for the recent few meetings that we all 7 commissioners joined this body, and we had like only several meetings that we all 7 of us reviewed several appeals. What is it that we believe, based on our review of those appeals, that didn't work? Where is it that we see there is a discrepancy, or there is a loophole, or there is a dangerous precedent that was set that can ruin the entire, then the whole thing will fall apart? Where is it that we saw that we're recommending to go page by page and change the ordinance or regulations? If we saw something in regards to a specific issue, let's discuss that. But I remember we had one case that we had a kind of a discussion, and maybe that triggered the idea of reviewing this ordinance. I forgot what was the issue, Commissioner. I think you brought up a few meetings ago. Maybe it will come back to me. But that was only one case for at least 12 years of me, oh, actually 14 years me serving on this commission, there was only one time that one case came up. It's not even a precedent. It's not even a case, a situation that will come back to you every other month that you have to to take some actions, or you'll be forced to take some actions or change something. So what I want to say is that we've got to be very careful whatever we do. I know everybody has a different opinion. We all know what is good and what is not good, what is working, what's not working. But the RSO has been working the way it is written now, perfectly fine. Unless if we find a loophole that really affects the outcome of the hearing examiners, that affects the outcome of our commission's rulings. So we should not disturb that. We should not undermine the provisions that are written and been working for decades, perfectly fine. So I guess I want to say we've got to be very careful what we're deciding to do here.
Commissioner Bergstein?
So I voted to agendize this. I was taught by former Commissioner David Gregoire, who stated once that no matter what we might have thoughts for anything any of our commissioners bring up, it's just courteous to allow anything to be agendized for discussion no matter what we think our feelings might be going into before the discussion on our agenda. But I am opposed to this. I think it is attempting to micromanage our staff. While there are a number of attorneys on this commission, I think really the kind of issues that are being brought up are better dealt with by our staff legal department. And this is just so overly broad. I want to echo Commissioner Topchin. I think that if there is a specific ordinance, or if there is, as Commissioner Topchin said, really in 12 years he recalls one of our decisions being overturned at the court level. So if we want to have a discussion about that, but this is just so overly broad, I'm just not in favor of this. I would be in favor of any time that any commissioner has an ordinance they think that needs to be reviewed, or if we think that something needs to be amended, or talking about a new ordinance, which we really can't pass, but we can talk to our council members about, that I'm always in favor of. But this blanket that this commission would be reviewing our ordinance in totality, I'm not in favor of that. I think that really more specific questions to staff and then agendize those specific questions. So I would be voting in opposition to this.
Well, I think I see some consensus here for at least making a list of some issues with ordinances that we would like to address, and at least getting the process started. I mean, I think we saw one tonight, that we have shade as a housing service, but not sunlight. I think that's a little weird. I think we could maybe look at that and see if we could maybe make a housing service out of sunlight. I don't see a problem there. So I guess my point is that I think that we could possibly, as commissioners, we have some experienced commissioners, sitting on the dais here, that maybe have seen some things that they maybe want to address or be looked at. Could we possibly form a list and have this as an agenda item at a later meeting, to have a list that we would, propose to this ad hoc or standing subcommittee to address, so it has at least a beginning to look at certain ordinances that we've listed out as commissioners, and then we get the process started, and then we address those and see where we go.
Could that be part of maybe our annual study session? Would that be a different way to start that conversation?
I agree. A study session is always the best place to create the child.
I'm going to throw in my 2 cents very briefly that I agree with Commissioner Bergstein in whole, so I won't add to that. I think it is micromanaging.
Why don't we wait, and we're going to have a study session coming up real soon, and maybe we could agendize that at our study session. Maybe the manager will make note of that and pass it on, so that we could have a full discussion beyond what we're having now.
So what sparked this was 2 things that I came across, and it sounds like the reasoning for some people not wanting to move forward with it is the thinking that the ordinance is being revised on its own without the influence, without commissioners instigating it. Was the one thing I mentioned, the NOI, that it looks to me like it includes an hourly rate that's far below the minimum wage. Obviously, that hasn't been changed on its own. The other one was under 1756-010. It says that the maintenance standards include providing a new carpet every 7 years. And as was brought up at the last appeal, there was a court decision that found that you can actually totally tear out the carpeting and replace it with carpet where the carpeting had been urinated on by animals and it was actually the equivalent. So some slight language could say, nothing in this shall require, shall prevent the replacement of carpet or, whatever with an equivalent housing service that is also maintained. So those are the two things that jumped out at me as not seeming like they had been updated on their own and why I thought there might be a need for it. And I saw that in the ordinance itself, the city council is required to look at this every year, and I just didn't think that was happening. So I didn't know if anybody was doing it. And in the absence of them doing it, given that our duties include actually crafting regulations and discussing housing policy, it seemed like it was incumbent on us to take it on.
Yeah, I mean, I think that, I don't know when the last time the 7-year and the 4-year for painting was revised, but I know that paint has changed over the years. I know that just by my own experience, I've not lived in very many places for more than 2 or 3 years, but this place I've lived in 6 and 7 years, and I'm like, it'd be a pain to have my landlord come in, and I don't even need my paint done, and I don't think he put anything special on my walls. It's just it doesn't need to be painted again. I'm not saying that applies for everybody, but that's one of those things that, like, with date and time and technology, things do change over time, and I don't want to comment like what you were saying earlier about making an opinion on things, but that's something that, probably if there was enough evidence, I could see that needs to be updated. But yet, in every single appeal, we're like, and I do it as well. This ordinance says this, and so we followed that. And that's one of those things where I kind of look at like, well, my paint's fine.
So are we wanting to move on creating a subcommittee, or are we not doing that?
We just thought that the study session would be the beginning of maybe bringing up the discussion on this type of issues, and let's leave it for maybe the study session when it's coming. I don't know, soon maybe.
Last year when we did the study session, we were told that's not really what it's for. It's to come up with things we study in the future. So unless that's changed, it didn't seem like an option based on how we've done things in the past.
Can we call a vote on the issue?
Sure, yeah, I mean, I don't think there's been a motion for making a subcommittee, so, I mean, we could make a motion and not have a second, and then we just simply have to move on. I don't think that we need to call a vote voting down the subcommittee, because I don't think that there's a consensus to form the subcommittee that we have on the agenda. So, I think at this point, there's a consensus to move this to an item on a study session. I see commissioners nodding. I don't know when our next study session is. Without a consensus for, to form a subcommittee, which I don't see, then I see that, staff, do we need to make a motion to add this to our next study session item?
If that's the consensus of the group to put that on the study session, that's not a problem.
So commissioners, if I don't have...
Note though, because I think Commissioner O'Keefe is correct, that the current format that we use doesn't allow for this, but that doesn't mean that we can't add this to our workshop or our study session.
Well, my understanding is what you're seeking to do is perhaps make a list of some of the issues that you're proposing to look at, then that seems to me well within a study session.
Okay, so that's what everyone else understood. I was thinking that we were just moving this conversation about subcommittee to the study session, but I'm fine with either.
Yeah, I was also thinking it was that way, but is what others on the commission think is that during the study commission, we'll come up with a list that in some way someone will address, hopefully, whether or not the ordinance should be amended.
I think we have consensus for that, and we can move on. Thanks very much. Let's move on from item 10A to item 10C, liaison appointments to boards and commissions. Thank you, Secretary Barino, and thank you for the request from the commission to make a list of when these meet. And let's sign ourselves up, commissioners. In your packets earlier tonight, there's a handout made for us about when the other boards and commissions meet. And I know some commissioners have preferences and where you'd maybe like to be a liaison, so let's hear them.
I'm going to jump in first since I've been quiet all night, but I would, for myself, like to do planning and human services. If others are interested in those, feel free.
May I, before everyone chooses, may I just give a little background on a liaison?
Thank you, Commissioner Roger.
For years, there was always one individual who represented us at all commissions. They would put the face on the commission. 2 years ago, we decided to divide that. And I think the problem we're going to have here is that some of us are going to want to go to the same commissions. Now, Karen taught me the other night that the definite article is the, and the indefinite article is a. So maybe, am I correct, madam? So I think if maybe we could consider doing this differently, that we can go to all of us, as long as we say we are a liaison and not the liaison. Because I know Rob, for instance, likes planning very much, and he has the experience going there. That doesn't mean you can't as well, but...
I think sharing is caring, and so I'm fine with that.
So therefore, I'm going to be sharing with you as well, because I like human services as well. I will not pull any punches being the senior here, but... all right, so... Chair,
I'm making a list.
How do you want to organize it?
I think that's fine. I think that's a great recommendation. If no one has any problems, if staff doesn't have any problems, then here we go.
I just want to mention that I have, in the past, gone to transgender, and I'm willing to continue to do that. Since I was the only non-senior many years ago, now that's different, but I actually served on the senior advisory as a non-senior, and I feel that's important that we relate all our rent issues to seniors, and I'm willing still to do that. And I still like disability very much. I think that is important in regard to how we help and provide those who are disabled in rent units. And of course, I like human services very much because I believe that's important, and I like historic preservation. And business license is the easiest because they only meet twice a year.
Not anymore, not with marijuana.
And now with cannabis, at one time it was a much different body when they had taxi cabs in their purview. And I don't know if the commission knows that we once had a gun shop for some years on La Brea Boulevard. And then the dancing and the music and all that, the First and Fourth Amendment sort of came in place there, and we weren't allowed to rule on any of that. And I actually like art and cultural as well. So I guess in essence, I'll be seeing you at a lot of...
Fantastic. That's great.
Can I just ask staff to clarify that? I just have to clarify that
if I spoke Russian, that might be, but that leaves Agassi and David Gregoire. I don't know if you knew, he was very fluent in Russian.
But don't count on me.
He won't be coming.
I think that just as a point of clarification, it's good that all of you may want to go to each one of these commission meetings, but it's important to at least assign a spokesperson. So if you do attend a meeting and you want to bring back information to the commission, then we know who the spokesperson is for that particular commission.
So that was my point of, excuse me, Richard. That was my point of clarification to staff that in the past, we have specifically said that an individual commissioner could not represent the commission as a whole at other boards and commissions. It sounds as if we're saying tonight that we may do so, or are we just saying I am a member of the Rent Stabilization Commission, I'm just kind of reporting on what's going on? Do we need to clarify how we would represent ourselves as we appear at other boards and commissions.
I believe the purpose of this is that if there's anything going on with this, within this commission, and you want to share that information in each individual commission, you can do that at the time. As well as if there's anything going on in that particular commission that you're attending, you can bring that information back here. So I don't think it's necessarily that you're representing a voice of the commission per se. You're just pretty much informing back and forth.
Of what we're doing and what they're doing.
Correct.
Right.
That's why I've come up with the articles, the or a, and I think that kind of solves the problem.
Other commissioners? Anything you want to, I mean, I'm a former member and chair of Business License Commission, so I'm fine to. Yeah,
Are you going there?
Yeah, I'd be happy to, be the formal liaison for business licensing. As you know, you're pretty covered, Richard. You're going to have a busy week.
Well, I think we've left out public facilities and public safety and transportation.
Yeah,
You're
I mean,
all-
I am a good friend of David Eichmann on transportation. If anybody else is interested in it, I'd be happy to be the liaison to transportation.
Do we have a transportation commissioner?
I go to public safety every once in a while. I could do that one.
Public safety?
I go to public safety every once in a while.
Thank
I
you,
could go to
Commissioner
that one.
O'Keefe.
And when we go there and announce ourselves, I'm wondering if maybe we could, if folks agree and if it's proper to say as the liaison, just give people in the audience and on the commission a brief introduction to what our commission does in case they don't know. And anything that would be a particular nexus for them, like with public safety, for example, maybe if someone's in rent stabilized housing unit and there are security features that are removed, then they potentially would have recourse after going through the appropriate steps.
And that's great. Public facilities, I don't have any up for Lesbian and Gay Advisory Board, Russian Advisory Board, and Women's Advisory Board.
So as in years past, I've declined from signing up for anything. My schedule won't allow it. I try to represent whatever represent means. I try to share with folks, whoever I meet with, or whatever commission I go in front of, or advisory board, just activities that I am involved with, and that includes the commission.
But you do go to a lot of housing community type meetings. I know we've met there before.
I mean, there's nothing saying we have to have a liaison for every commission. We can just assign the ones that are of interest to our commissioners and where we have connections and move on.
And I think there's some where there's not necessarily much nexus between our service and, something that would necessarily overlap between the two commissions in some
Right.
cases.
So, I mean, we have something informal going on. I realize that from what staff has said, there has to be some formal one person. Does there have to be a formal one person for, these liaisons? Can we have two people show up and say they're the liaisons for Planning Commission? Because that's the one that people are interested in the most. I mean,
Yeah, it doesn't have to be formal. If two of you went to that meeting and only one of you attended the commission, coincidentally only one of you did, then the person that is here would be reporting the activity that you guys were informed of.
So two people can represent themselves as the liaison from rent stabilization.
Absolutely.
There you go. Okay.
I think because Commissioner March took my two favorites, but I'm happy to yield to a newer commission. I think I'll just continue attending commission board meetings as I'm able to, and if there's no one else representing from our commission at that meeting, and I feel there's appropriate comments, I'll make them as a member of the commission without being the formal liaison.
I would, in the alternative, say that, as staff has said is allowed, is that two people can be liaisons. I mean, I don't think that I can make every single meeting. I don't know if you plan to, so, I think we're adult enough to figure out who's going to what meetings, if we're both there, how to share the microphone, I don't think we need to make a formal rule, but I think if we limit it to two, we won't have a critical mass of 1,000 people there, and we're adults to kind of figure out how to go to meetings and talk.
Fantastic.
Yeah, I'll say for my role, I wasn't planning on going to every single one of the meetings. I was planning on introducing myself once and maybe going if there's something relevant.
All right, for our last item of new business then, let's move on from item 10C to item 10D, rotation of chair and vice chair. Commissioner Maggio, I know, wanted to introduce this, having been on the commission for a while, and let's go.
All right, well, I've only been here a short time, about 25 years. And as we all know that the city of West Hollywood was established in 1984, rent stabilization was established in 1985. 1985, so it's one of the oldest commissions. From 1985 to 1994, there was only really 2 chairs, and one of the chairs, who I know very well, was chair for about 7 or 8 years. It was really difficult to unseat him. But in 1994, Jeffrey Prang, Kevin Notre, and myself, Richard Maggio, joined the commission, and Mr. Prang suggested a rotation, which was voted on. And for 22 years, we rotated by the date and year we were appointed. Interesting enough, it wasn't until 2000 that all the commissions followed our direction, and they rotated. Now, you know, the rule is you must rotate the chair every year. But that doesn't mean that that chair can now rotate back in. So, but this commission always practiced literally as Commissioner Garrett, Charity sits now. He would simply sit where Agassi is, and then he would move down to where Josh is, and down to where Kalen, and they come all around. Now we're 7 now, so it will take a little longer for that person to get to that place. It does affect the seating, the rotation, and I must say the secretary's been very good about making sure we keep part of this rotation, even though it has changed a little. So I suggest we continue it. I think it gives everyone an opportunity to be chair and vice chair. There's no politics involved. You just move into that position unless you do not want it. If you do not want that position, then the next person in line simply sits in that chair and becomes first, of course, vice chair and chair. Now, very seldom has a commission gone from not being vice chair to chair. Garrett Charity is an example. And I think he reminded me there was 1 or 2 other examples in the past. So I guess what I'm asking, would the commission agree that that is a custom or a tradition that we should continue? Or does the commission feel that we should always throw it out? Is that fair to someone who might be sitting here for 3, 4, 5, 6 years and never have that opportunity? So I think that's how I would like to lead off the discussion.
I have a question for Ms. Regan. The commissions sometimes, and advisory boards, I think there have been examples over the years where we've kind of gotten in trouble with the Brown Act and how commission chairs have been chosen by in certain years. Wouldn't this require a bylaw change for us, since we are setting policy basically moving forward for commissions going forward? Or would it just be a policy that if we decided this, how do we do this if we choose to without violating the Brown Act? Because couldn't somebody just next year, even though we have this policy, couldn't somebody just say, no, I nominate so-and-so and go out of line?
I'm sorry, this is just about deciding whether to rotate the chair and the vice chair?
He's talking about an actual rotation, like 1, 2, 3, like he's not talking about moving the chair and vice chair out and putting a new one in. We're talking about an actual lineup.
Next time, yeah. Well, it's my understanding we've had that in the past, or at least an informal. So it wouldn't be, there's no Brown Act issue. It's not, you're not doing something, you're not codifying something. So if the commission wants to informally agree amongst yourselves to do it that way, you can, but your point is a good one in that if the commission makeup changes, then that can change as well.
No, I mean, I don't mean to say no.
Well,
My understanding, without giving specific examples of which advisory boards, is if we make an informal decision amongst ourselves, that's a violation of the Brown Act. if we do it outside of this meeting.
No, you're doing it now.
So we would be
It's on
agreeing.
you agendized it.
That's what I'm asking. That's why I'm asking. This is confusing to me because, so we agree tonight that, okay, I'm going to be, or he's number 1, 2, 3, 4, 5, 6, 7, and then that's just the way we rotate. When we all, 5 years down the road, come to our annual meeting where we do that, and we know going into the meeting, I mean, how is that fair to the public to know that?
Could we maybe have it publicly announced each time, so if we have new members, we know, like have a motion that, I don't think if we wanted to bind ourselves, I think we'd have to do it in the bylaws, but I don't think we need to bind ourselves. I think we can just have an agreement, if we want to, that that's how we'll want to do it going forward, and maybe be reminded each time we vote on a chair, and vice chair, who would be next in the rotation, and if we all agree, nothing's going to happen to us if it's not in the bylaws if we don't do that. But that's my thinking of how this could go.
Is a public agreement right now, is that sufficient to not create a Brown Act violation in the future?
And it makes sense what you said, Commissioner.
Commissioner Bergstein, I know you had a comment.
I do. So, and I've spoken about this before, that this was the only commission that I'm aware of that for many years was a 5-member commission. There were no at-large appointees, and a lot of the commissioners served for significant terms on the commission. So back when the commission had that particular makeup, I think it did make perfect sense just to kind of rotate as far as seniority. However, it's been 4 years, I think now, that they've added the at-large positions. And I've brought this up before, saying that we've had commissioners who've served, and served well, multiple terms as chair and vice chair. I'm not negating the quality of their service, but we have since had commissioners, because they weren't in direct rotation, have not had the opportunity to serve as chair or vice chair. I was kind of taught by Aline Windeman, who was the former director of Housing and Rent Stabilization. Particularly, I was on that unwieldy body of the East Side PAC, which was 36 people. She said, you don't repeat chairs and vice chairs unless there is no one who would like to step up, that you build stronger commissioners and stronger commissions by allowing everyone to have that opportunity. So I said we've had 2 commissioners who did not have that opportunity, Maggie Buckles and Stephanie Harker. I don't know if they wanted to, but they were not given the opportunity because under a former group in this commission, there were a few of the longer-served members who were adamant about it goes in direct rotation. There was actually a comment going, you all can wait 7 years. Now, that commissioner did apologize later on, said I shouldn't have said that. And it does not always go in strict rotation. The vice chair did not become the chair for the current, and that's the way the vote went. But I'm not negating the quality of the service from our longer-serving members who have served numerous terms as chair and vice chair, but I think that if anyone would like the opportunity to serve, we should be able to nominate whoever we would like. It should not be in strict rotation.
Let me add that Stephanie Harper told me personally she did not want to be vice chair or chair, that wasn't a job she wanted to do.
I think we're getting off subject because I think that the rotation would allow every new person to be chair before another person was chair again. So
That's exactly.
The rotation, I don't see that being a problem with rotation because if I'm understanding correctly, the rotation would mean that always someone who hasn't had it would be there before somebody who has been chair.
Exactly, and if the person doesn't want it, it simply goes to the next person.
It could be a long
Rotate.
time for somebody to get a chair a second time just because of makeup of
Exactly.
the difference of.
Got it. We went out of place for the last 3 years. You became chair a year earlier than you were supposed to, but I'm glad you had the opportunity. There's an example. Josh was a new person. Of course, Josh was here, gone and back. He's been here 3 times, so he was chair. Turned out that Garrett Charity became the chair. So let's put it this way, Rob. You're the vice chair, and you will be the chair. If you are reappointed to the commission, you will be the chair next year. But then the vice chair should be Karen. And then she should move on to the position, and Kalen then comes around here, and he then becomes vice chair and goes on to be chair. Now, Be rest assured that Richard Bonjour will not be vice chair or chair ever again. I've been vice chair 6 times and chair 6 times, so believe me, as you can see, it's already a challenge, and I still persist. But I see that as being the normal way to do it. It creates a better seating situation, and I would hope that you would all support me on this.
Commissioner O'Keefe.
I like the idea of a rotation. I feel a little awkward whenever I have to vote on people because I'd be happy to have either chair typically and would rather not have to choose. So if it's a rotation, then everybody gets a turn unless they don't want it. I would suggest one amendment. I would suggest that no one be a chair until they've served in the commission for at least 6 months or a year, because I personally think that I wouldn't be a good chair if I didn't have a little more time to understand how things work. But yeah, I like the idea of a rotation.
I think we're all in agreement.
By 2 years, you would have already been here 3 years, so, you know.
So commissioners, can we move forward with a friendly handshake that we will rotate chair and vice chair?
I just want to say a very quick thing. It's a ceremonial position, obviously. The chairperson is just running the meetings. It's a wonderful tradition. Of course, everybody wants to run the meetings, but there's also the situation is that the chairperson gets to speak the last, obviously, and the chairperson gives a chance for everybody else to speak, and you always speak the last, and everything was already said, and there is really nothing much to add. So there is also that. The chairperson should, obviously always remember, keep in mind whoever is going to be serving next. So, and you've been doing a great job, although you didn't, this was the first time you as a chairperson here. I'm fine with whatever commission decides. I like the tradition of rotating the chair, vice chair, and chair, and I think it's a great tradition. So if everybody agrees, I'm fine with it.
Also, just one added note, the chair always votes last.
And I'll add my 30 seconds or less of comments that I see the value in both options being weighed today. I like friendly competition. I also see the value of ceremony and tradition. To me, this is probably the lowest priority thing that we've discussed tonight. So if someone wants to make an informal motion that we're not voting on, then let's do that, because our staff looks tired. Mr. Green looks tired. I'm tired, and I think we've beat the horse a little bit.
And this is the first time in many years we've had a 3-hour meeting. So, yes, indeed, I agree.
Okay.
Oh, have we agreed?
I think we've agreed. I think we have a consensus.
All right.
We don't have unanimity, but I think we might have consensus.
So that's what so we're good then, right? Agreeing this? Okay.
There's no Brown Act problems.
Yeah. Okay, so let's move on. Item 10D to item 11, public comment. We have no public comment. Item 11 to item 12, commissioner comments. Yes.
Josh, did you give us this assembly legislative to report?
Oh, yeah, I did, but not really. I just gave you a list and set one in the back of the room, and I think everyone, Mr. Green, got a copy. It was just a list of bills by Assemblymember Richard Bloom this year, housing and not housing related, just his batch of bills. And I just wanted to say thank you to all of you for the discussion this evening on the not even so much on the 1-year issue, just the fact that we were able to talk about that and kind of express our opinions on this commission and what we feel that this commission is responsible for. And I appreciate your guys' time, and I know I spoke for a very long time then, and so I appreciate you listening and moving that forward.
Commissioner Bergstein?
Commissioner O'Keefe brought up at our last meeting about assistance for tenants when they are approaching the hearing process, and going through my rent stabilization folder at home, I did find Hearing and Remedies, a guidebook. Do we still give this out at the desk?
They are still available, yes.
So it kind of helps them through the process without showing a bias to either party, correct?
Correct.
Thank you. Commissioner O'Keefe, did you get a copy of this in your, if not, maybe we can make sure everybody on the commission has a copy of this at our next meeting?
I could definitely help.
Thank you.
One's for tenant and one is for owners. There's two guides. The green is the renter guide, and this one is there's supposed to be two booklets.
Any further, oh, sorry. They're in the back of the room as well, those handouts. Any further commission comments?
I just want to make 4 motions for things to put on the agenda next time. Just kidding. Apologies that I kept you all so long. We did.
Very funny.
I would not second that.
Moving on from item 11 to, item 12 to item 13, staff comments. Very good. Well, with that, this meeting is adjourned. Thank you.